I miss Charlene a couple of days now. All right, so let me go ahead and jump right in. So first of all, feel free to ask questions. I leave time at the end for questions, but as we go through, you may have questions that pop up. I've tried to think about things and setting this up in terms of what you may need to know, as most of you being new in this industry. So this is set up as kind of an overview. In some areas where I know that you'll deal with day-to-day as a community manager or an assistant manager or even in the accounting, I get into some of the details. But I mean, I've taught these classes for all-day seminars, for multiple-day seminars, and in a couple hours, depending on what the needs are. So when I spoke with Sherry, Charlene, and a little bit with Carol about how to set this up, we thought a big, kind of the overview, broad, in terms of the various topics, and get a little bit of detail on the things I think you'll hit every day as you start out in this world. So a couple things to understand: that it's not just community association documents you need to be concerned with when you do this world of community associations. And let me start off when I'm talking about community associations. What does that mean? It means homeowners association, condominiums, cooperative associations. And there's various different things, like for example, there's master associations or sub-associations. We'll talk a little bit about the distinctions that are there. There's old terminology for some of the documents. There's newer terminology, and I'll try to highlight some of those things. I had, for example, somebody brand new in my office, fresh out of doing a judicial clerkship for a judge. They came in, and I told him, check the declaration for this. And he came back and he said, Jason, I've looked. I don't see the declaration in the binder you gave me. There's just a master deed in the bylaws. Well, master deed is the declaration, but old school condominiums, sometimes they call it a master deed. Same thing. And so even a guy fresh out of law school didn't understand the terminology because wasn't familiar with it. So don't feel bad as we go through and as you get into this world of things that you may not know, because it's new to everyone. So beyond the documents, there's federal, state, and local law, whether you're in the county or the city. I'll talk about condominiums, homeowners associations, community associations, and cooperatives. Transition of control from developer to homeowner control a little bit. That's for newer properties. I'm going to talk about role and responsibility as board members, what your roles and responsibility as managers or working with the management company is. Understanding the documents. I'll talk a little bit about the design review process and procedures. Maintenance of property standards, covenant enforcements, assessments, collections. And it's a lot of information, which is why I've tried to give you as much detail in the materials that I gave you, so that when I'm gone after today and you forget what I told you, you can look back and it's right there for you. And if not, as hopefully your colleagues will tell you, I'm just a phone call or an email away. Always happy to help out even after today and giving you guidance on stuff. So let me talk about characteristics of a common interest community, which is also something community associations are called. So how they're created is something to understand. So first and foremost, whether it's a community association, which is a homeowners association, or condominium, the first thing that the developer or the declarant has to do, and the developer is the entity that buys the land, develops it, and creates the association that people are going to buy into. And it's called a declarant under condominium documents, and oftentimes in homeowners associations it's called developer, or so the terminology means pretty much the same thing. In the legal documents, in a condominium they refer to it as one thing, in a HOA they refer to it as another, but basically it's the developer. And in a condominium, sometimes you'll have a developer that bought an existing apartment building and then converts it to a condo. But for purposes of the legal documents and everything else, they're still considered the developer or the declarant who created the condo regime. So in a condominium association, they record the declaration, which I'll talk about what that is in a little bit, and the bylaws in land records. So if anybody's ever bought a piece of property or understands that when you buy a home or a condominium unit, you get a deed to a property. That's a transfer from the owner of the property to you as the purchaser. And that deed gets recorded in land records, which is an office down at the courthouse where they keep track of everything going back to as far back as sometimes the 1800s, depending on what courthouse you're in terms of who owned what property and what tract of land. So when you get a deed to a property, it's recorded in land records. Well, just like a deed, the association documents, the declaration for a condominium and a homeowners association are recorded in land records. And the reason they're recorded in land records is whoever buys that property takes it what's called subject to, which means they're bound by what's recorded prior to them getting that property in the records. So if you kind of picture a timeline, if you record the declaration here, and then you take that property by a deed, and if it's in what's called your chain of title, which is the timeline of history for that property, whatever happened before you, you're on notice of it, and you basically buy into understanding that you're subject to whatever came before you. So the declaration, once a developer gets that property, first thing they do once they've subdivided the property, let's say it was a big farm, and now they've got 200 lots that they're going to sell off. Well, that declaration basically now applies to all those 200 lots. And before they start recording those 200 deeds to transfer to whoever's going to buy it, everyone's on notice that they're taking it to whatever's in those association's documents. So basically, whether you actually knew about it or not, actual knowledge doesn't matter, because in the law it's called constructive knowledge. If you'd done some due diligence, you could have done a title search and found that it was in your chain of title. And every deed for property also recognizes that, because when you sign it, the really fine print that those lawyers put in there says subject to all covenants, deeds, easements of record, which means you take it subject to what was there before you. And when you buy in, you take that property, you're basically agreeing to be bound by whatever's there. So you're taking it subject to those terms. So the governing documents create a mutual obligation between the members and the association. And it's basically under Maryland law, DC law, Virginia law, every law in the country, a recorded covenant is considered a contract. So we'll talk a little bit later about how those terms are enforced, but basically it's contract law. So when you buy subject to those covenants, you're agreeing to all those terms. Sometimes whether you like it or not, you're stuck with it. So in terms of things to understand what the hierarchy of governing documents and what's there, for a homeowners association, and I'm going to refer to them as homeowners associations, community associations, all means the same thing. When there's distinctions between condos and HOAs, I'll try to draw those distinctions for you because there are differences. But so for a homeowners association, they record what's called a site plan, which is basically, if you picture a big farm and they do that division into 200 different lots, that's part of the site plan, where they say how the community is going to be laid out, whether there's going to be pools, playgrounds, what have you. It's all part of that site plan. And there's a whole approval process. I could spend a whole day on telling you that process, but we don't need to worry about that for purposes of today. But so the developer basically gets a site plan approved by the county or the city, and then is off and running and developing and building on the property. Sometimes there's a site map or a plat for a condominium. So for a condominium, they don't record a site plan, but very similar, there's a plat that's recorded in land records that sets out, for, if you picture a building, it shows basically each level of a high-rise building, how it's going to be laid out and what's there. Some condominiums, there is a site plan that's recorded as well if it's part of a larger community and there's land that's being developed. But what's recorded in land records for a condominium is the plat, and it's part of the declaration and the bylaws. For again, homeowners associations, condominiums, there's a declaration of covenants, conditions, easements, and restrictions, CC&Rs, is sometimes referred to. More modern documents, depending on who the developer was and what attorney they hired to create the documents, they try to get a little creative now with what they call those declarations. So they used to all be called CC&Rs. Now they call them different things. Sometimes they're covenants, declaration of covenants, constitution. So we've got one developer and does a lot of property in Ocean City, Delaware, Montgomery County, and he uses a lawyer that likes to now call the association's governing documents the Constitution. But if you read the fine print, it's still just a declaration. The board of directors is who's set up to control that. We'll talk about it. But even in that new set of creation documents where they call it a constitution, instead of it just calling it a board of directors, they call them the board of trustees, just to make it sound more important. It's all the same thing. Associations can be either incorporated or unincorporated. Most homeowners associations these days are incorporated entities. A lot of condominiums are still unincorporated. The reason why is Title 11 of the Maryland Real Property Article, which is the Condo Act, says that a condominium can be either incorporated or unincorporated. But it's all the directors, even if it's an unincorporated association, has the same protections as even if it was a corporation. So we'll talk about what those protections are a little bit later. Bylaws. So if you picture the Declaration of Covenants, Conditions, and Restrictions, it's also called a master deed for some condominiums, as I noted before. That sets out kind of the guidelines and the restrictions on what you can and you can't do with property, what you can and you can't do in the building. And it sets out those restrictions. The bylaws is really the meat of operations, especially for a condominium. So in a condominium, typically the declaration is like 8 or 10 pages, and then all the meat is in the bylaws. Talks about the restrictions, what you can and you can't do, talks about easement rights, talks about restrictions, talks about who the board is, what powers they have, who the members are, what they can and they can't do, how meetings work, what the budget process is. So for whatever reason in a condominium, somebody in the infinite wisdom decided to put everything and all the meat in the bylaws. But for a homeowners association, what you'll find is the declaration is the meat. That's usually like 30 to 40 pages, or if these constitution documents, I've seen them as much as 80 pages, where it gets through every detail of the restrictions, the easements, the obligation to pay assessments, the board, the membership, is in the declaration for an HOA. And the bylaws is simply kind of like corporations set them up. It's just operational issues. How the board's elected, how the membership meetings work, how the association establishes proxies and ballots and those types of things. So one thing to understand is that altogether these are the governing documents, and all of them are important. And we'll talk about the hierarchy, but I wanted to point out in a condominium, when you're looking to find the meat of really what's there, it's going to be in the bylaws. For HOAs, it's typically in the covenants, the main declaration document. And then in terms of going from there, you have rules, resolutions, and guidelines, and we'll talk about that. So again, there's lots of different types of governing documents in terms of how they laid them out. For the most part, there's the same format that's followed, as you'll see if you compare one association to the other. So some association documents classify everything as a rule and regulation. And we'll talk about kind of what that means. But whether it's a policy resolution, administrative resolution, special resolution, general resolution, some documents get into all those details. For the sake of and purpose of what you need to understand is, for all intents and purposes, all those different types of resolutions or policies are all on the same level as a rule and regulation, irrespective of what they've called it. In terms of other things that are in the governing documents, there's mandatory fees. For an association to be created, for it to be either a homeowners association or a condominium, what distinguishes it from any other type of group or citizens association is the obligation to pay mandatory assessments. So if there's no obligation to pay mandatory assessments, then it's not subject to the HOA or the Condo Act because there's no mandatory obligation there. There's associations that were created back in the late 60s and early 70s that had recorded covenants where they required architectural guidelines be followed, but there was a voluntary payment of assessments for the kind of the social good of the community, but there was no mandatory obligation. So in fact, I have a couple of clients that I call citizens associations, which are basically groups of homeowners that are subject to the same set of covenants in a community, but there's no mandatory obligation to pay assessments, which means they're not subject to the HOA or the Condo Act. The only thing that governs them is the recorded documents. The other thing that the association owners share is they all share an interest in the common area of property and facilities. And that's laid out in the documents, and we'll talk about what that means. But essentially, when you have an HOA or a condo, it's not just the individual units or the individual homes, but the property that supports the complex. So if it's a condominium, the hallways, the elevators, the lobby. If it's an HOA, the playgrounds, the pool, the other facilities, the streets, the sidewalks, those types of things. Those are typically owned by the entity association, not by the individual. And we'll talk about the distinction in ownership with condominiums when we get into a little bit more here. Yes?
You may expand on this later, but if you could talk a little bit about what types of events would trigger a resolution of the board as opposed to a document amendment. And
Yeah.
if we talk about now or later, that's fine.
Yeah, I'm going to get to a little bit later. So the hierarchy of legal documents. And this is important for understanding when boards try to do things and you as the manager can say, well, wait a second, you can't do that. Or call the lawyer, make sure this is right, or have them review it. so there's a hierarchy, which basically means what controls over what. So at the top of the food chain, if you will, if you picture a ladder, I'm a visual guy, so I like to do this kind of thing. Okay, so at the top of the ladder, in terms of the documents, up here, you're going to have the declaration. Then below that, you're going to have the plat if you're a condo. Okay, if it's incorporated, the articles of incorporation. Then you're going to have your bylaws. And then you're going to have rules and regulations or resolutions. Okay. So what this means is, in terms of the ladder or hierarchy of documents, is if it's in the declaration, the bylaws can't conflict with it, because the declaration is going to trump or override what's in the documents that are lower in the food chain or down the ladder. So a board, as we'll talk about, typically has the power on their own to adopt rules and regulations. They can't adopt a rule or pass a resolution that's in conflict with anything that's higher in the ladder. So if the bylaws say assessments shall be fixed at $1,000 a year and you can't increase them more than 10% a year every year going forward, they can't pass a resolution that says, let's bump up the assessments 25% every year, because it's in conflict with the declaration. So it's important, because the boards will often try to say, well, the bylaws say this, but let's adopt a rule that says something different. They can't do that because it's in conflict. And if it's in conflict, see, now it makes sense. You have the materials. That helps, right? So you can't pass something by a resolution that's going to be in conflict with the bylaws of the declaration. So the hierarchy matters. Sometimes, it's rare, but sometimes you actually find inconsistencies between the bylaws and the declaration. And you throw it to the lawyer and say, well, which one's right? And I'll have to say, well, based upon the hierarchy, the declaration provisions are going to control. So I had a situation where in a condominium, the declaration said the windows were the association's obligation to repair, replace, and maintain. And the bylaws had a provision that said it was the unit owners, because the developer, or really the attorney that drafted documents, messed up. And so the bylaws were trumped or overridden by the declaration, irrespective of the fact that it said something different. And the Maryland law, the statutes, the HOA Act and the Condo Act specifically say this as well, that in terms of there is a hierarchy and what controls over what.
Excuse me, you're saying the bylaws trump the declaration?
No.
Oh. Okay.
Here's our ladder, the declaration's at the top.
Okay.
So it trumps
the
it.
declaration would be.
Yeah, overrides the bylaws. So that's the kind of the hierarchy. So, but beyond the hierarchy of the documents, you have federal, state, and local law. And there's the specific federal laws that there's a lot of them, but the ones that you'll deal with most often are Fair Housing Amendments Act, or the Fair Housing Act, which prohibits discrimination in housing based upon familial status, disability, race, national origin. And familial status, just to put that in English as opposed to legal terms, basically means you can't say a family isn't a family because it's not a husband, a wife, 2 kids, and a dog. So if there's partners, even if it's unmarried individuals living in the same house, you can't classify and say single family purposes only, which is the term in most documents, means that it's got to be one family unit. You can't say, well, you can't have the grandparents or the cousins or the nephews and the nieces because it's not one single family unit. Can't do that, violates fair housing. Can't discriminate based upon disability, race, national origin. I have a community that was created in the 1940s that had a provision that didn't allow African American individuals to be in the community. Guess what? Federal law says it's no good. We all knew that, but believe it or not, there's documents still out there that say that back from the 40s. Now, the association amended the documents to take that out, but I was amazed that there was actually a recorded set of documents that still have that in there. Yes?
This may sound like a dumb question, but it's
Wait,
an interesting question.
there are no dumb questions.
Okay, so I come from the multifamily housing world and HOA. Never dealt as in depth into HOA because I was more on the software end of it. So these fair housing amendments and all of this still apply to HOAs, condos,
Correct.
all properties.
So a distinction I will draw for you, because it's a mistake that's often made, is that people will say that the ADA, the Americans with Disabilities Act, won't let you do that. Well, the ADA is a federal statute similar to fair housing, but it only applies to places of public accommodation, which basically means that places that are open to public access, such as shopping malls, apartment complexes where there's a leasing office. But as a homeowners association or a condominium, it's a private entity,
Right.
private community. The ADA does not apply, but the very similar laws from the Fair Housing Act apply. And one main thing to understand is, under the ADA, it's the obligation of the owner of the property or the association to provide accommodations on its own. Under the Fair Housing Act, the obligation to provide accommodations for disabilities and what have you only comes into play upon the request of the occupant or the owner of the property. So it's different. The ADA basically says that if you go to put in a new sidewalk, it has to be ADA compliant. Fair Housing Act says you may not have to do curb cuts so long as it still meets the code. But if somebody asks for one, you might have to give it to them. So that's the distinction. So the ADA doesn't apply to associations unless there's portions of the community that are open to the public. So I have some mixed-use communities. Mixed use means basically residential and commercial. So the commercial units are open to the general public. So the means of access from the parking areas to get to those retail stores and what have you, the ADA applies to those sections, but the fair housing applies to the residential sections that are limited to private residential communities only.
I mean, that's just interesting because it's always pounded into you when you're in multifamily housing. I can't tell you how many classes I took on that.
Yeah, so and that's an important thing. And so the general rule of thumb is if you get somebody making a request for, quote, an accommodation, that's kind of one of those buzzwords, typically I tell the managers, have your attorney look at it and have them review it. Because if you violate the Fair Housing Act, what happens is the community can be hit with a minimum of a $1,000 fine, and any individual that was deemed to have violated the act also has personal liability exposure for it. So you don't want to mess with it. Other things that come up under federal law: parking, disabled parking, handicap parking. I talked about the ADA and Fair Housing Act distinguishing factors. Reasonable accommodations, we've talked about that. So, there's two components to reasonable accommodations. There's accommodations that somebody will make as a disabled owner for, I want you to accommodate me so I can make physical modifications to the property, my individual unit, or the common property. So it can come up in that context. I want to put in a curb cut. I want to put in a wheelchair ramp to get to my front door. So where the architectural committee might typically say, I'm going to deny the request, having that ramp on the front step is going to be ugly, we don't want it there. Because of disability law, it's going to require you to accommodate and allow them a means of access, so typically you're going to have to allow it. Now you might be able to say, make it look pretty, but you still have to allow the ramp. The other context that comes up is accommodations in terms of overriding or modifying the association's rules, policies, practices, and procedures. Again, what does that mean? If you've got a provision in your documents that says no pets allowed, but the person needs a seeing eye dog or an accommodation animal, and I'll talk about that in a second, then that would override your policies and procedures that says no pets. And so what happens there? They have to make a written request to the board for consideration, giving appropriate documentation saying, I need an emotional support animal, this is a big one these days, to accommodate my disability because I can't function without the animal. So I have a property I work with right now in Pikesville, in Baltimore, that is a no pet building. And they made a request to allow their dog. And it's been in litigation now for 2 years because whether the dog is really needed or not needed or whether it's just a farce. But at the end of the day, they're going to allow the dog because there's now been documentation saying it's an emotional support animal and the woman needs it to accommodate her disability. That's what they have to do. Other things, Telecommunications Act, another federal law. So OTARD, over-the-air reception device regulations. OTARD for short. What does that mean? There's FCC came out with a ruling, probably going back now, probably at least 10, 12 years, that said satellite dishes. DirecTV would not be able to be in business had this rule not passed. What this said is an association can't prohibit satellite dishes. So 1 meter in diameter or less, The association has to allow satellite dishes, even though most association documents created prior to 2000 had provisions that said no dishes, no antennas, what have you, can be on the property. Now, the OTAR regulations only applies to satellite dishes. And it basically says an association can't prohibit them unless the association offers the same comparable technology to get the same reception. So, for example, I represent a property in Gaithersburg that didn't like having the 14 dishes on every single unit on the front of the property. And so they installed their own dish and basically let everybody tap into it. And then they could tell people you can't have your individual dishes because you can have access to this, which gets you the same reception that you're looking to get. Problem with that is people move in from another country and the regular satellite system doesn't work. It's a special system, and so now they have a dish for theirs. And so while it was a good idea in theory, in practice it's not working anymore because the technology changes and things get modified. So they can't prohibit them. Solar panels is new. Last 2 years, 2 years ago, federal and state law was passed that said you can't prohibit somebody from putting solar panels either on their property or on their home. And people often say, well, can't we tell them where to put it? And the answer is no, because from a practical standpoint, typically when the guys come out to say where they need to be installed to get the best reception of the sun's rays, they're going to give them the optimal reception. The only way you can say no to either a satellite dish or the solar panel placement is if you can prove that they can put it somewhere else to get the same reception that they're trying to get now, and that it doesn't interfere with their ability to get the optimal reception. At the end of the day, solar panels, they can be anywhere on their property. You can require them to hide the wires to make it look pretty, but you can't prohibit them. What we've done is we've created for a lot of associations kind of some form documents that basically suggest people to put them on the back side of the roof and those types of things, but at the end of the day, you can't stop them from putting them where they're going to get the optimal reception. State law. You've got the Homeowners Association Act, or the HOA Act, the Condominium Act. If you're in a cooperative, you have the Residential Cooperative Act. There's corporate law. There's the Non-Stocked Act, which basically applies because all associations, for the most part, except for cooperatives, are non-stock corporations or unincorporated associations. Non-Stocked Act applies as well. And the Maryland Contract Lien Act, which really kicks in with respect to collections, which we'll talk about. Then you have county and city laws. Often you've got parking and towing regulations that are passed by the county or the city. You've got, in Montgomery County especially, there's Article 10B of the Montgomery County Code that has a whole set of provisions that applies to HOAs and condos in the county that deals with proxies and votings as well as other things we'll talk about. You have zoning regulations that can come into play, and you have maintenance standards. We'll talk about that when we talk about enforcement. So again, I've already talked about some of these things. So planned unit development basically is community association. That's just, the old term is PUD, planned unit development. Master association, mixed use, I've told you what that means. So you can have a sub-association, which basically means there's a global master association for a community that's an HOA oftentimes, but within the HOA there's also a condominium association. So people who live in the condo are paying condo dues, plus they're paying to feed a master association to use those facilities. That's quite common these days. Common area properties, common area facilities. So what does that mean? So common area properties is like the patch of grass that's out there that the community has an obligation to mow and maintain. Common area facilities, and I'm using these terms because you'll see these in the documents that you're going to be working with. Common area facilities means the pools, the clubhouses, the tot lots, anything that has something physical on it that has to be maintained is considered in the documents the community facility that has to be maintained by the association, and we'll talk about obligations for reserves as well. And reserves is a fund that's created, basically it's like a savings account for future maintenance, repair, and replacement of those what's called capital improvement items or the physical structures of the building or the facilities. Condominium associations have common elements and limited common elements. Now this is a huge distinction. So if you're dealing with an HOA versus a condo, in the HOA documents it's going to refer to common areas, which basically means, like I said, the lawn, the tot lots, the parking areas, what have you. In a condominium association, the ownership interest is different. So in an HOA, basically when you become a member, when you buy into a homeowners association, you become a member of that organization. you basically you're a stakeholder in the community that you now live. But the community, and I said oftentimes an HOA is an incorporated association, so it's a separate entity. So, for example, if it's ABC Homeowners Association, Inc., you buy in there, well, you're now a member of the ABC Homeowners Association. Well, being a member of it basically means you have a right to vote, you have the obligation to pay assessments, you can get elected to the board, but the buck stops with the board that basically has control and makes decisions for the association. As a member, you can try to influence the decisions that are made by the board, but you have no direct power with respect to the board that makes the decisions on behalf of that organization. The difference with a condominium is, and with the HOA owns that common area parcel. So, for example, the pool is on a piece of property. It's called a lot. And typically it's parcel something, parcel B, in the land record documents or on the site plan. So parcel B is where the pool is. Well, you don't own anything in parcel B. You just have a right to go in there and use the pool. In a condominium association, it's different. You actually have an ownership interest in everything that the condominium has. So, for example, the building, the pool, if it's all part of the condominium, and let's say there's 200 owners, and you're one of them, and let's just say you all have an equal share, you have a 1/200th percentage ownership interest in everything the condominium has. So you've got a little piece of everything. So what does that mean? That means that they don't call them common areas, they call them common elements. Why, I don't know, but that's what they call them. So common element is basically a distinction in condominiums that means somebody owns a piece of it besides just the association. Because in fact, the association doesn't own anything, unlike an HOA that owns the parcels. And a condominium, if you look at the site plan, there's actually no parcels set up. The condominium has this whole piece of property, and it's all subject to the condominium regime, that's what it's called. So basically the condominium set of documents. And everybody owns a little bit of piece of everything. In the condo docs, though, it says who manages and controls it is the board that gets elected. But everybody's got an ownership interest. And that's an important distinction, because when we'll talk about the restrictions that you can pass and put in place for a condominium, it's a little bit different because everyone has an ownership right in everything. The law says you can't take those things away as easily as if you could in an HOA, because in an HOA you've opted to let somebody else control it, but in a condominium, because you have a little bit of piece of everything, you have what's called an easement right, and that can't be taken away willy-nilly at somebody's whim. And we'll talk about that when we talk about enforcement.
So far, there's no question about that, right? Because that's just so important.
Yeah.
Why? No question about it. If it is, we now
Because this is a complicated aspect of this. Yes.
So if they wanted to take the pool away out of a condo, they had to vote on it or something?
Correct. So here's a good example. That's a good example. So I had an HOA in Frederick that was in dire straits from a financial standpoint. And the board decided in its infinite wisdom to close the pool for a season to save that money, whatever it was, $50,000 a year to run the pool. In a condominium, the board likely doesn't have the ability to shut it down because everybody owns a piece of it. So they'd have to vote to get rid of it or to close it up, because everybody has a percentage of ownership interest. So it's an important distinction, because the powers that are given to the board oftentimes are restricted in a condominium that would otherwise not be in an HOA. Again, it's that ownership interest that makes the big distinction. Yes.
Would it depend on what your covenants and restrictions say for the HOA? Because I'm on a board of my own, and usually there's like a 66 2/3 vote that you have to do for certain things. I can't recall what that is right now. So,
Right. So basically, everything always is going to come back to the documents in terms of who can do what and what voting requirements exist. So, and when we get into the meat of it a little bit, you'll understand this a little bit more. But like in the common elements of a condominium, because everybody has a little bit of a piece of it and ownership interest, you can't just take away those rights to those things typically without a vote of everyone, versus just a board being able to do it on their own. In fact, there's a case, the case on point is, it's called Delaney Towers. You don't need to worry about that. But So this was a mixed-use building that had a residential, it was a high-rise, and then it had commercial units on the first floor, and then residential units above. And the residential unit owners got sick and tired of all the retail customers walking through the nice, pristine lobby. So the board passed a rule that said the commercial unit owners and their guests or visitors couldn't walk through the lobby. They had to go around the back and use the back entrance to the commercial area. And it went all the way through the courts, and the court said, no, this is a condominium. And even though the commercial unit owners in this condominium, they have an equal right to use every piece of the common element lobby that the residential owners does. And you can't, by a rule, take that away. Two things. One is it conflicted with the bylaws and the declaration. But more importantly, this was the case that kind of highlighted the distinction between common areas and common elements and said, because the commercial unit owners owned a piece of that lobby area, you couldn't just snatch it away from them. It's like a taking. It's taking away a right to property that they otherwise had. And so that was a huge distinction. The other thing in terms of the documents is limited common elements. So typically common elements is something that the association has an obligation to. Now I'm switching to repair and maintenance obligations. Maintain, repair, and replace common elements is typically under most documents with the board of directors of the association to make sure that the association pays for. There's distinctions where that gets changed, but we'll talk about that later. But as a general rule, if it's a common element, your mindset should be, well, it's probably the association's obligation. Limited common elements is basically, it's still a common element, but it's something that's set up for the exclusive use of a specific owner or owners. Best example is you have a high-rise condo with a balcony off a specific unit. Well, everything that's on the outside of the building in most condominiums, like a balcony, is often considered part of the common elements. It's not defined as part of their unit boundaries. It's outside the unit, but it's there for their exclusive use. Because let's say that Charlene had a condo unit with a balcony. I couldn't say, well, I'm another owner. I own a piece of her balcony. I can go use that anytime I want. Doesn't make sense. So what the law says is that balcony, even though it's something that the association has to maintain and repair and replace, but it's reserved for her exclusive use adjacent to her unit. So they call that a limited common element. It means something that's reserved for the exclusive use of a specific owner or several owners. Another example is parking spaces. Sometimes in a condominium, parking spaces are assigned to specific units. And that can be set up as a limited common element. Again, there's sometimes it's not, but you see that often. There's also sometimes storage units that are set up as limited common elements. It gets complicated because some condos now are creating the storage units, garages, and parking spaces actually separately deeded items. So then it actually becomes a storage unit versus just a limited common element, which is why understanding the documents is important. I'll get to your question in a second. Most of the association documents for condominiums, so there's the declaration that's recorded, and the declaration incorporates by reference typically Exhibit A. Exhibit A is typically the bylaws. Exhibit B is oftentimes the unit listing with who has what percentage of ownership interest. And I actually got that reversed. Usually Exhibit A is the owner listing of which unit has which percentage of voting interest. Exhibit B is usually the bylaws. But the listing of which units are there, it'll say, unit 101, 102, 103, and so on. But also if it's set up parking units and storage units, they'll be listed there also. And I've got a condominium that has 200 residential units, 25 commercial units, 300 parking units, and like 50 storage units. And as you'll find in condominiums, it's usually based upon square footage. So a one-bedroom unit has a bigger voting interest and a three-bedroom unit has a larger square footage. So typically has a larger percentage of ownership interest in the condominium, which means they have a bigger voting power and a higher obligation to pay assessments. And then going down the line, a two-bedroom is a little bit smaller, one bedroom is a little bit smaller than that. And then even these storage units, parking units, and what have you, have these teeny little percentage of ownership interest that give them voting rights also. So that's why you need to understand in the documents, are they units or are they just specifically reserved for somebody's use? You got a question?
I was wondering if condos declaration, or if the units are deeded a parking space, an assigned space, and it actually has the dimensions of that space listed, there are no changes that you can make to the physical parking lot that go against the deed or the declaration. Is that true? If you wanted to increase the size of the parking spaces, would that be an issue?
So if the parking spaces are deeded in terms of this space belongs to this person, as just like a unit, so basically it's a defined square footage, you're right, you can't change the square footage of that parking unit without typically going to the membership for a vote or to change it. In most instances, parking units are typically done as garages, or whether internal or external garages. It's rare that you'll have a parking space, well, I would say rare. It's not as often you'll have a parking space that is deeded without the ability of the board to modify the areas. So even if it's deeded, sometimes the board is given the authority to change assignments and reassign if it's a limited common element specifically assigned to a unit. But if it's a separately deeded parking space, then you're right, they can't change it without, because that's changing a property right.
Okay.
Yes?
Who fixes the balcony in a limit, if it's a limited common element?
Okay, so typically anything that's a common element or a limited common element, typically the structural maintenance, the main meat of what's required to maintain, repair, and replace is typically with the association. Now, actually I got a question yesterday where it said that the balcony was a limited common element and the association had the obligation to maintain, repair, and replace the balcony, but the owners had the obligation to keep it well kept and maintained. And basically what that means is keep it swept, clean, looking good, don't keep clutter on it, that kind of thing. So, but that's and the reason is in a condominium why they leave the board or the association entity with the obligation to maintain balconies is because it's a structural component of the whole building. And if you left it to the individual owner to worry about replacing a balcony that's a slab of concrete in some instances, and it fell apart, well, that one balcony, if it fell apart, would impact and affect everyone around it. And that's why that theory is there. It's also important on insurance, which we'll talk about. So let me jump ahead to control. So in the situation of whether it's a condo or an HOA, the governing documents set up who has the power to control it. So again, whether it's a master association or homeowners association, the governing documents will set out who controls what in terms of the property. So if you've got a master association with this big plot of property and within it you've got 3 or 4 sub-associations that are condos, typically the master association is responsible for the big picture and then it accepts out like the little pieces that condominium owns. So for example, again, I'll use this whiteboard that's so handy over here. So if you've got the master association like this, but you've got these 4 condo associations within it that define these boundaries of the condominiums, typically the HOA master association's going to be responsible for all this stuff in and around here, but within the condominiums themselves, within these circles, each individual condominium is going to be responsible for what's in the 4 walls of their community, so to speak.
Cold spring.
So, and that can get complicated. Gatherings at Linwood's another one. I'm not going to get into a great deal of it now, but there is something also called a land condominium. They're rare. You don't see them too often. But a land condominium is something that's kind of its own little hybrid. It's the same concept as a master association, but typically because of zoning and approvals with the town or the county, they set it up as a land condo instead to get the approval that they needed to create it. I have a property in Ocean City that's like a mini city in and of itself that has 8 sub-associations, a master association, and they're all subject to a land condo. It's pretty complicated. The land condo doesn't do anything but basically make sure that the whole operation keeps running, and then basically it's just a figurehead board that does nothing. It's really the master association that controls the property, but it's there because of regulations that were required by the town in setting up the community to basically make it its own gated community to set it up. So in terms of control, the governing documents will set out who controls what. So it's either going to be assigned to the board of directors or committees. So you have some associations documents that says, and most of the documents are set up like this, the power and control of the community, whether it's the HOA or a condo, is vested in the board of directors for the most part. Day-to-day operations, management, who hires the management company, who hires the attorney, who gets the accountant, who sets the budget. Oftentimes, it'll be delegated to the board of directors. And it's perfectly legal and proper for an association, even a condominium that has everybody owns a little piece, to basically delegate the power to the board to control the community day to day. And then there are some things that are reserved for a vote by the individual owners. And we'll talk about some of those things. But the day-to-day stuff is typically left to the board. Some association documents, and you typically find this not in condominiums but homeowners associations, where there's a committee set up for architectural control or covenant enforcement. Now, most documents say that you can have a committee, but the ultimate final decision rests with the board. But there's some documents out there to be mindful of that basically say there's going to be a permanent covenants committee, and their sole duty is enforcement and determining maintenance violations and covenant violations. And it's like a little entity in and of itself for purposes of enforcement. And it doesn't even give the board the power to step in that little purview of enforcement unless the covenants committee enforces and then somebody appeals the decision, and then it goes to the board like an appeal. So some documents, again, it's probably 10 to 15% of the documents that are out there now, have these committees themselves that are given this sole power where the board's not even supposed to get involved. I represent Avenel, which is over in Potomac, and their documents basically, nothing goes to the board until it gets to an appeal in terms of covenant and architectural control. The architectural control and covenants is purely vested in these two permanent committees, and the board can't even intervene unless somebody appeals it. Again, you don't see that too often, but there are some communities that are like that. The delegation of duties, again, the bylaws is typically where you're going to find this, and it's going to tell you whether or not the board decides it, or does this guy have to go to the membership for a vote. So most documents say the budget's adopted by the board. The board hires management. In terms of elections, the members elect the board of directors. And then among the board of directors vote to who's going to be what officer position. And in the same vein, and it kind of makes sense, if the board of directors is elected by the membership, to remove a board member, what makes sense? Can the board vote themselves to remove another board member? To oust the oddball in the group? No. If the members elected the board, the only way to get a board member off typically is for the members again to vote them out. So that's a question I get quite often in terms of, well, so-and-so is a recluse, he's kind of creating all kinds of problems on the board. Jason, can we just get rid of him? Let's get somebody else in there. And the answer is typically no. For the board can't just remove somebody. The reason you have a 5, 7, 9 member board is to get varying opinions and differences to make hopefully the right decision for the community instead of a decision by one person. So it wouldn't be fair if me and my 3 other buddies decide to vote Charlene off the board because she's kind of creating problems for us. She's always giving us these other ideas, we don't like them. She's always voting against us. Well, let's just throw her out. You can't do that. What you can do is, because, again, the board is vested with the power to determine what officers are going to serve with you. So the board gets elected and you've got 5 people. Now we got to decide who's going to be the president, the vice president, the treasurer and secretary, and the other person is typically called the at-large member. So we as a board vote to decide who's going to be what officers. It's kind of like selecting the employees or the personnel of the group, who's going to do what. And so the board amongst themselves votes and decides who's going to be president, vice president, secretary, treasurer. If we decide we want to change it later, because we determined it in the first place, the documents typically will say you can re-vote, throw the guy out as president, and re-elect new officers. So you can do that as well. The officer positions from a practical standpoint don't mean a whole heck of a lot. because the decisions of the association, when they're given to a board, is made by the board of directors as a unit. And so what does that mean? Is you need a quorum of the board to conduct business. What is a quorum? More than 50%. So if you've got a 5-member board, you've got to have 3 people to conduct a valid meeting. And I often get the question, says, Jason, they all can't get together. What can we do? Can somebody give a proxy to another board member to show up at the meeting to vote on an issue? Board members can't give proxies to each other. It defeats the whole purpose of having a board get together and decide issues as a unit. So if I'm going to be at the meeting and I can't be there, I can't give my proxy to my buddy to go to the meeting for me as a board and vote as a board member. Now what I can do, which is something I've encouraged a lot of boards to do, is especially with you get boards where people travel, especially in the summer, well, Jason, we can't get everyone together, what can we do? Well, technology. So we can allow somebody to call in and be on a conference call. And the law says so long as they can hear me and I can hear all of them in the room, it's valid, as if I'm there. You can Skype, as long as, now the visual part of it doesn't matter. So long as they can hear me and I can hear them, that's what matters. Now, if I'm on the phone with Charlene and she's communicating what I'm saying to everybody else, that doesn't work. Because that's not a conference call. That's not where everybody can hear or see me at the same time. But if you can do it that way by conference call, the person that's participating, it's valid. But if you can't get all people there to constitute a quorum, again, in a board of 5, let's start with this. You'll have boards of 3. You need 2 of the 3 there to be a quorum. Board of 5, you need 3 of 5. Board of 7, you need 4 of 7. And a board of 9, you need 5 of 9. Again, more than half to constitute a quorum of the board to conduct business. If you don't have a quorum, nothing can take place. Because technically under Robert's Rules of Order and under the corporate law, if you don't have a quorum, which is the minimum number of board members you need to conduct business, no business can be transacted. They can't make decisions. So it's not a meeting. Now, oftentimes the practical is, and one thing that you'll learn from me or working with me or just here today, I'm all about the legal and the practical. Okay, anybody can give you the law. Anybody that's a lawyer should be able to interpret the law and tell you what it means. The real meat of it is, practically speaking, how can we apply this? So look, if you get all these people that show up to a meeting, and you know what, darn it, it's a 7-member board, we've only got 3 people here, we can't do anything, but there's a room of 20 people, what do? Take the opportunity to have a town hall type meeting, which is basically, the board can't make decisions, but you've got people there, you can at least discuss kind of what's going on. Nothing official can be done, the board can't vote, but the manager could at least report on here's where we are with this project, here's what's happening. The board members that are there can say, we can't make decisions, but what we've got coming up on the horizon, hopefully next month we'll make a quorum. We're looking to hire, get a new pool company in here. We're looking to hire a new trash company. Whatever may be going on, you can at least have a town hall discussion so the whole time isn't wasted with people that are there. This often happens really with your annual meetings as well, because for an annual meeting, your documents will set forth what the minimum quorum requirements are for the membership meeting. And oftentimes, if you don't do your legwork up front, you'll show up and you haven't met your quorum requirements for your annual meeting, and you have to basically redo the meeting on another night and continue it to do it another time. But yet you might have a room with, like I said, 20 people, 25 people, but darn it, you needed 30. Take the opportunity to at least have a discussion with those that showed up. And if you're really smart, you'll have proxies there, get them to fill them out. So when they don't show up at the next meeting, at least have their proxy so you can at least get that to count towards quorum so you meet the requirements for the next meeting. And we'll talk about proxies and quorums a little bit more later on. But your documents will say whether the board or the membership has a right to make decisions. When it comes to amending the governing documents, it's always going to be a membership vote. If it's a condominium, to amend the bylaws, by state law, it's 66 2/3 if you're in Maryland, unless otherwise provided by the documents at a higher amount. So I have a condominium that had a 75% amendment requirement for their bylaws. So what do? We just amended their documents by 75% to say that they can amend their bylaws going forward at 66 2/3%. So now it'll be a little bit easier for them. But to amend bylaws, it's always going to be at least 66 2/3 of the community for a condominium. For HOAs, it can vary. Sometimes it's 50%, sometimes it's 2/3 to amend the bylaws. Amending the declaration, because remember it's the higher or the highest document in the chain, to amend that is typically a supermajority requirement. So for HOAs, typically it's 90% of the community to amend the declaration, and then typically after 30 years, it'll drops to 75%. For condos, to amend the declaration, oftentimes it's 100% to amend the declaration. Why is that? Because everyone has a percentage of ownership interest in everything. So if you've got one naysayer in the room, you might not be able to amend the declaration. Now, amending the bylaws is different because the declaration typically is who owns what and how people pay. Excuse me. So the amendment requirement is that much higher and much more difficult. That's your question.
Yeah, the Condo Act trumps anything that's already in place for the association, correct?
Good question. Sometimes.
Okay, because I was wondering about the majority. If the Condo Act says that 66 2/3 is sufficient, then why would someone's declaration saying that a higher number take precedent?
Right. So this is where the lawyers sometimes have to give guidance. So the statutes say, sometimes they'll say, unless the governing documents provide otherwise, this is what the law is. An example of that is the amendment provision I just talked about. So the statute in that case for a condominium says, unless the governing documents require a higher percentage, bylaws may be amended by a vote of 66 2/3. So no condo can have less than 66 2/3 to amend it, but if it's got a higher percentage, you got to go with the higher percentage in the documents. Other provisions of the Condo Act or the HOA Act says, unless the governing documents provide otherwise, here's what the law is. So if the documents say something different, an example of that is, so 11-108.1 of the Maryland Condominium Act talks about who's responsible to maintain, repair, and replace an association components. And it says that a unit owner is responsible to maintain, repair, and replace their own unit, and the association is responsible to maintain, repair, and replace common elements. But because it says unless the governing documents provide otherwise is that first part of that sentence, you got to check the documents first. So for example, oftentimes in a condominium, the windows may be defined as part of the unit, but the maintenance, repair, or replacement obligation is with the condominium association. Because even though they define it as part of the unit, it wants the condominium conceptually, because it's kind of part of the structure, how it looks from the outside, wants everything to be uniform. So I have a condominium right now in Chevy Chase that is grappling with the issue because their documents define the windows as part of the unit. The documents don't say anything different in terms about maintenance, repair, and replacement obligations for the windows. And now the building's 40 years old and people have to replace their windows. So you've got different owners putting in different style windows. Now the board can adopt a guideline that says we all want all windows to look like X, but because the prior boards weren't as diligent in keeping up with it, you've got some people that have a window that's a white window, some have the off-white, some it's beige, so it's a mess. But you have to go back to be careful in reading the statute because sometimes it'll defer to the documents, sometimes it won't. An example where it doesn't defer to the documents is closed meetings, which we're going to talk about a little bit later. The statute there does not defer to the documents. It doesn't say unless provided otherwise. It says open meetings shall be held as follows. A board of directors may only hold a closed meeting for the following purposes, and it doesn't default to the documents, so the statute controls.
And kind of the second part, because you mentioned that you were amending someone's declaration or bylaws to get them 66 2/3 instead of whatever it was.
75, right.
Why that instead of simple majority?
Because the Condo Act says you can't drop below 66 2/3. So we took it from 75 to 66 2/3, which is the lowest they could go. And again, HOAs is different. The other thing to be mindful of as well with documents in terms of what the minimum requirements are for quorum excuse me. Sometimes, not for quorum, for voting, sometimes it'll say a vote of 66 and 2/3% of all owners. Of all owners, sometimes it'll say of those present at the meeting. So there's a distinction there. So typically in a condo, it's based upon a vote of all ownership. In an HOA, it could be of those present at the meeting. So it might say 50% of those, 51% of those present at the meeting, or it could say 51% of all members. So you have to be careful what the actual requirement is.
You wanna take a little break?
I was going to go 2 more minutes. Let's see if I can get there. Role and responsibility as a board member. So, again, powers pursuant to law and the documents. Let's run through this. Board members have the authority to set goals for the community. Basically, determine what it's going to do for the community. Are we going to look to establish new pool guidelines? Are we going to stop pet restrictions? They can set the agenda. They can set standards and procedures. And I'm losing my voice, so let's take that break now. So why don't we take like 5-minute break? So 11:25, and then we can go together.
Casey, you're very good.
I was just, yeah. Did you get a packet?
No.
Charlene or Sherry? Jason.
For condos, it can be greater than that if it specifies docs, but it can't be for condos. And that's for quorum.
No, that's for many documents.
Many documents, okay.
Quorum is set.
Okay, so it'll say, okay. Thank you.
Come back out of slideshow.
And all the other 1A1B and all of that.
I heard that one.
I
I was like, yeah, it's all coming together.
Winterset, I don't know who you have worked with Winterset, but you probably will see that.
Yeah. It's called Winterset.
Winterset.
I haven't had it come across them yet.
Yeah, that had different.
Right. So like a sub.
Yeah.
I'm gonna pause our recording here through the break. Whose job is that? Is that my job?
It was yours at the time, it was delegated to you by me.
You have personal responsibilities.
I delegated it, I'm a delegator.
You're a delegator?
I delegated it to you to do, and you were like too busy to do it.
Is that gonna be your new job title back here? Just a delegator?
I
You'll get a to-do list and you'll just give it out to you.
delegating. Why is this end shorter than the other end? It's because they're supposed to face a certain way. Oh yeah, you're right. It's supposed to be the other way. You're right.
Too far. How do you get here?
We'll give it another minute. I think we got a couple that are waiting to come back in. So this, am I going okay pace? Not too fast, not too slow? Good. All right.
Just go all the way around. It's impossible. Well, it's not impossible, but
Yeah, I just drive through the city, so it's a 15-minute drive instead of a 40-minute drive, but I get to see some of the beautiful parts of Baltimore.
I have the commuter's pass, so I only pay about $40 each trip.
Okay.
So it's, I mean, it adds up, but it's not terrible.
I'm probably sure that I will probably cave in eventually, but as of right now, I'll pull up to a red light every so often. I'll get heckled. What you doing, little Prius?
See, I don't like driving through
I'm
the
on
city
track
in my
with my
car
water.
because it's a stick, and it's
I'm on
just,
track with my
I'd rather
water.
just be constantly going and try to toll. Like if there's gas mileage that way, it kind of works itself out. If I'm just
All right.
constantly at like 65,
So-
70, then
I will
it's nothing.
get going again. We're ready, and let the other people jump in when they're come on back. All right. So I was talking about powers pursuant to law of the documents, and that all set?
Yeah, it is.
Okay. So again, the authority set goals is going to be in the governing documents. Typically, in the bylaws section of your documents, it's going to say powers and duties of the board of directors, and that's where you're going to find kind of where the board has these broad powers and authorities set out. It'll say the board of directors has the authority to adopt rules and regulations with respect to the common areas and facilities. So again, something to be mindful of and pay attention to is a lot of associations and managers actually believe that the board was given authority to adopt rules and regulations with respect to everything pursuant to that statement I just read you. Where in fact, if you break it down, it said, Board of Directors shall have the power and duties to adopt reasonable rules and regulations with respect to common areas and facilities. Doesn't say individual lots. So for many, many years, boards were adopting and passing rules that said what people could and could not do on their individual lots, based upon that provision that really did not apply. Now, there might be other provisions of the documents that give them that authority, but it's not the one I read you. And why that's important is because that same provision sometimes would say, the Board of Directors has the power to adopt reasonable rules and regulations with respect to common areas and facilities, and impose sanctions for any infractions thereof. Basically, the fining language. But because it gave them fining power for violations on common areas and facilities, but didn't say the right to fine for violations on individual lots, courts were saying, guys, you can't be fining people for having an ugly house, for painting their shutters purple, for putting flamingos in the front lawn, because you don't have the authority in your documents to fine people for those things. So a lot of the documents, I'd say, recorded before 2000, be very cautious for a homeowners association, because the documents might not give the association the power to fine. The reason I say 2000 or before is because after 2000, some of the more modern documents being drafted started giving individual provisions that said that the associations had the authority to impose fines for violations on the individual lots. So that's something to be careful of. Yes.
And you would go to the declaration of the bylaws to look and see if it said anything about finding.
So you always start in the declaration first
Okay.
to see if there's fining authority in there.
Oh.
At the very least, you might find it in the bylaws. And it would be in this power section that I'm talking about. Powers and duties of the Board of Directors. Enforce the governing documents. We give the board, as I just said, the power to enforce the governing documents. There's oftentimes an additional provision in the declaration itself that talks about enforcement power, but typically also in the bylaws it talks about broadly or generally the board's power to enforce the governing documents against owners who might be in violation. It'll say that the board of directors has the obligation to ensure that the association's common areas and property is specifically maintained, repaired, replaced, what have you. Something else to be very conscious of when you're looking at associations' governing documents and you read the thick documents. If you're reading them and if it's a word that's, beginning of every sentence, the word is capitalized. But when you read governing documents, you'll find that sometimes words in the middle of the sentence out of nowhere will be capitalized. Well, that's a signal to you because we lawyers get creative. Okay? So when we draft documents, we capitalize terms or words that are defined somewhere else. So if you're reading the documents and it says the board of directors shall have the power to adopt rules and regulations with respect to the capital P property, that's a signal to whoever's reading it to go to the definition section of the documents to see how property is defined. And in most documents, you'll find the word property is defined to include common areas, facilities, and the lots. So if the word property and it's capital P, and it includes the definition that says lots, there you have it. They have the authority to adopt enforcement powers for violations occurring on the lots also. So the word unit in condo documents is going to be defined. and that'll describe what a unit is. Typically, you'll see limited common element defined. You'll see other words defined, such as if you're reading a master set of documents and it talks about condominium, sometimes condominium is defined, and it'll specifically say in the definitional section what condominium association is talking about. I represent a master association called Park Potomac out in Potomac, Maryland, off of 270, and that's a hodgepodge. Talk about a mixed use. They've got a master association, they've got a sub-association that's a HOA, townhouse community. They have 3 apartment buildings, they have a commercial section, and then they have 2 condos. So talk about a mixed use. And then they've got this whole section of the property that's dedicated to the county for a bus depot at the corner of the property. So there's all kinds of different things. And so for that community, which is something sometimes you may need to do for your communities, is figure out who's responsible for what. In a mixed-use community, you've got everybody pointing the finger at everybody else. So in the community I just described, it took about 10 meetings with the developer, the commercial owner, the HOA board, the master board, to sit down with engineers and a big community map that we color-coded to highlight who's responsible for what. Because from this curb to this curb, the master. From the curb to the front of the building, it was the condo. But the commercial owners had the parking lot next to it. So, I mean, it was all kind of a hodgepodge. And sometimes in these large mixed-use communities, you've got to figure out who's responsible for what. Don't just assume that when you get a letter from somebody, and oftentimes it's the neighboring HOA or the neighboring condo, saying, you all didn't properly maintain this, you've got to fix it. Don't just jump to the conclusion, well, they must know what they're talking about, because they may not be. So you want to verify what their claim is accurate. Yes?
When you have setups like that where there are 3 or 4 different types of body inside of one master, do they need to have at least a common thread in their declarations, or do they need separate ones, or does it just, was there one big declaration that said we're also making these ones, or do they all need separate?
It depends. So oftentimes the larger communities, and that's one of those legal things that goes, it depends. But the large master communities often will contemplate that they'll be creating sub-associations later in time, and it'll reference it. For example, the one I just talked about, Park Potomac, what actually ended up to be 3 apartment buildings was originally anticipated that they would be condos. But of course the market fell apart. And so instead of building condos, they built apartments. And so it really, you have to go to the definition section where it says what parcels they're talking about to know that now it's the apartments. So oftentimes it'll contemplate it for the larger communities. Other times there'll be reference to annexation. Annexation is a legal term that basically means the ability to add additional property to this community. So what developers do in creating property is, so let's just picture that big farm, or kind of picture this community. So let's say Mel created, as a developer, this whole community, contemplated A, B, C, and D condos. Well, oftentimes he reserves the right in the documents to say, plus, for 30 years I can annex additional property if I so choose to bring it into this community association as well. And so 5 years down the road, Mal purchases Mr. and Mrs. Smith's farm next door. He wants to make it part of this master community for marketing purposes because it's a better thing. So he'll record a new declaration that supplements this one that adds this piece of property to this association. And that's called a declaration of annexation. So, and what condo developers do is, if they're creating multiple buildings under one condo regime, they'll do it in phases. And they'll record new declarations of annexation for each phase. The reason they do that is for warranty purposes also, and also for purposes of how the assessments work. Because for assessments for a condominium, so if I create a condominium of 200 units in one building, as soon as I sell the first unit, and I'm the developer who still owns the other 199, as soon as I settle on those units, even as a developer, if I still own 50 units, even though nobody's living in them, but they could be occupied because they're livable units, they've been settled and ready for sale. As soon as I start selling in the building, I have to start paying on the units that I own as a condominium. So, as a builder or as a developer, I don't want to have all 4 condominiums come online, all 4 buildings come online at one time, because that's a huge amount of money for me to start paying into the association for assessments. So they do it in phases. So they'll sell out building 1, then record the annexation to add building 2, 3, and 4, and so on. And that's why they do that. And there's also warranty issues that come up with that we don't need to get into today. But the other thing the documents will do in terms of the powers of the board, it'll say the board has to maintain financial stability of the association. It won't say it in those terms. It'll say basically the association has the obligation to the board has the obligation to adopt a budget and set the assessments and collect assessments, establish reserve funds. Does everybody know what reserve funds are yet? Okay, well, for those who are not answering because they don't want to be embarrassed, reserve funds is that future savings account. So basically, if I own a pool, according to my reserve study done by an engineer, he's going to say in 30 years the pool's going to need a new white coating. It's going to need a new bathroom facility because it's going to fall apart. 30 years, new concrete. So what I have to start doing today is to save for that future repair and replacement. And the law has said in these governing documents, we're going to make associations save for tomorrow. The reason they do that, and some people you actually may not know this, the reason there's a mandate for reserve funding is to basically protect future owners in this community. Because my parents bought into a community in 1971 in a homeowners association, and about 40 years after they bought, they sold in year 39, the pool needed to be completely gutted and redone. And the nice young lady that bought from them when they sold and moved to a condo, would it be fair to her to basically get stuck with a special assessment for $30,000 to go to the pool replacement? No, right? Wasn't her that lived there for 39 years or 35 years and got the benefit of that pool. She just bought in after the fact. So what the documents do is it creates a requirement that associations set aside money for those future repairs or replacements so that people living there today are helping save money for tomorrow for the future owners. And so that way when the nice young lady moved in year 39, she didn't get hit with a special assessment. Instead, the association had the money set aside to do the pool replacement. Now, the difference between, I know some of you have an apartment background, in an apartment complex or an apartment owner, they don't worry about tomorrow because they're only worried about today. And they don't care what happens to the future owner because that future owner is going to take those facilities and the dilapidation of the property into account when they go to sell it. So if you don't know this, when someone's going to buy an apartment building, they do what's called a due diligence study, and they have a property assessment done, and they learn that, hey, that pool's going to need to be replaced. Well, it's going to cost you $50,000, probably a low-end price to replace a pool, but let's just say it's $50,000. So let's say the property is being sold for $450,000. Well, the future purchaser will say, no, I'm going to give you $400, so I got to spend $50 to replace that pool. But in a community association, because you have individual lots, they don't think about it the same way. So they force the savings through the reserve fund. That's why they do that. It's going to require them to purchase adequate insurance. So the documents talk about insurance, but so you're aware, so does the state law. State law says every condominium, every homeowners association has to have 3 kinds of insurance. You have to have general liability insurance, which is a slip. Basically, if somebody slips and falls on my property and goes to sue me, I'm protected. It also applies if there's a sudden occurrence of a storm, a hurricane, a tornado that takes the roof off the building. That's covered. Sudden casualty. It's also going to require directors and officers liability insurance. What does that mean? Well, you've got a board of directors of the association. If somebody sues them for decisions that they make, then that D&O coverage kicks in to protect them. And every type of insurance, there's 2 components. There's what's called the duty to defend, which basically means that they'll pay to hire a lawyer to defend the lawsuit that's brought. That's important. And the duty to defend in every insurance policy is absolute. If there's coverage, they have an obligation to provide a lawyer to defend a lawsuit that's brought. The second component is really the liability side of it. Is if I'm sued and I lose, who's going to pay out on that claim? That's the liability component, which the insurance company, if it's a covered casualty, let's say it's the roof that flies off the building in a storm, there's no lawsuit there, but they're going to pay to replace the roof. If I get sued for a slip and fall, they're going to provide a defense for the association in that lawsuit. And if there's a payout, the association's insurance company is going to pay out on the claim. Unless, anybody who's familiar with insurance knows, it falls under an exclusion under the policy. So typically there's exclusions under policies of insurance that say, we'll pay out for negligence. You forgot to put salt down and somebody slipped and fell. Well, okay. But sometimes insurance will have exclusions and say that, it's not negligence, it's gross negligence or an intentional act. We're not going to pay out on that. So, for example, if, and this is rare, but let's say, for example, the association knew that this area needed to be salted because somebody slipped and fell 3 times. So now you're on notice. It's icy today, somebody slipped and fell, we knew about it, we should have put salt down. 3 days goes by, 3 more people fall. Well, by day 4, people are still slipping and sliding. The insurance company may come back and say, well, you know what? Now it's not just negligence, it's gross negligence because you knew about it, and that's going to fall outside your policy. It's rare that those things come up in a negligence situation, but there are exclusions under policies that say that the carrier may not pay out. They still have to pay for the attorney, though, to defend the claim. But depending on the ultimate liability, they may not have to pay out on the damages.
What if it's the vendor's fault for not salting? Like, what if the association told them salt out all areas or something like that?
Excellent question, because there's the association's insurance.
What was the question?
The question was, what happens if there was a vendor that was responsible for putting the salt down and they were negligent? Well, that's what we call a subrogation claim, which means somebody sues me, the association. Now I try to find somebody else that may have been responsible as well, and I sue them. That's a subrogation claim. So if I pay out on this claim, then I sue the contractor for breach of contract and go after them. I often get hired by insurance companies to defend associations who get sued, even if it's clients that I don't represent because I have a relationship with insurance companies. And the first thing that I do in looking at those cases is do just that. Was somebody else at fault for why I've been sued? And I did have a case where somebody slipped and fell on their patio because a contractor was doing work and forgot to put up the barrier so that somebody couldn't walk out on that area while they were doing work. She came out in the middle of the night, didn't realize the contractors had gotten to her patio to do work because it wasn't blocked off. She went out to get, I think, the cat in or something stupid, tripped and fell in the hole that was there. And so she sued the association, and we immediately filed what's called a third-party claim against the contractor because in their contract that we had with them, they were supposed to secure and make safe the property area to prevent that from happening. So those things happen all the time. It'll also say that the board of directors has the authority to enter into contracts on behalf of the association. That's how you as management companies get hired, how we as lawyers get hired, how the accounts get hired, how the landscapers, the pool companies, how they get hired, because the board has the authority to contract. Now, from a practical standpoint, and Mel might correct me on this, some management companies, and I think yours as well, are sometimes in your management contract with the board, sometimes you're given as the management company the authority to enter into small contracts for the association so that everything doesn't have to come back to the board. Whether it's to hire a handyman up to $1,000 to fix the plaster that's falling off in a lobby or something like that. So sometimes the management company contract will give you some authority where you don't have to always go and get board approval for every single thing. Mel, do your contracts have some of those?
We don't do that.
Okay.
But we have the ability in an emergency to act, but not to enter into contract.
Okay.
So we have an obligation if the work exceeds $2,500 to secure a contract. So we don't sign contracts for utilities for example.
Right.
But the other things are the insurance with the attorney. These are contracts that are all presented
To the board for them to sign.
Yeah.
And that's actually, if the association, that's the better way to go. you don't typically want to have the management company signing contracts on behalf of the association. One is it can put your head on the line as the manager of the management company if you sign a contract and then the association decides not to pay on it or tells you not to pay. And then the other issue too is the relationship is really between the association and that vendor, not with the management company and the vendor, because they're not landscaping your property as a management company, they're landscaping the association's property.
And it's a very common thing when you look at where people have been taken advantage of by management companies, where they are in fact controlling the contract situation.
Right. It's a whole, yeah, and there's a whole other conversation about how there's these large management companies basically try to push their vendors on the communities, which is a whole different headache that we see out there as the lawyers. Other important components of the governing documents. So you've got a lot of reading ahead of you as managers, just in case you didn't know. The governing documents of your communities are going to have things that you need to check when it comes to election of directors, when it comes to setting budgets, when it talks about rules and regulations. Everything in the world is going to be, for the most part, in the governing documents. So other important words to look out for besides just capitalized terms. The words may versus shall. So if the documents say that the board of directors may adopt rules and regulations, it's discretionary. They can if they want to. They don't have to. But if the documents say the board shall adopt a budget annually, it's a requirement. Two very important words. So if the word shall is there, they must do it, whether it's annually or whatever is specified in the documents. Must adopt a budget. They shall maintain adequate levels of insurance. They shall employ a management company to do professional management. Some documents have a provision that doesn't allow self-management. Actually, a lot of them do nowadays. That requires professional management of the community because they don't want to leave it to the volunteer board members to run sometimes a multi-million-dollar association without professional guidance. It'll also prohibit certain acts. Limitation on the amount of assessment increase. Older HOA documents have this quite often, even some of the newer ones do, that says that associations going from year to year can't increase the assessment by more than 10%. There's a lot of documents that were created in the late 70s, early 80s, that's for HOAs, homeowners associations, that said the annual assessment amount shall be $500 and cannot be, you can't increase the assessments by more than 10% from year to year. That put a lot of strain on a lot of communities where prices increased and they were stuck with a 10% cap on increasing assessments. We don't see that so much anymore with documents. Condominiums never have a cap, at least in my experience. Instead, it says the condominium has a right and the obligation to adopt a budget to meet its expenses. Because of the condominium building, expenses ebb and they flow, whether it's increase in rate of utilities, whether it's the surcharges that you get from a trash company, what have you, those things are out there.
Can I ask a question about this?
Yes.
We've had a client that did not raise they had a percentage in the HOA, percentage in the document. Can't raise it more than 5% of something like that. And then, but they didn't always do that. They didn't raise it for many years. So we went back and we computed what they would have gotten if they would have raised it at 10% from when the place was built in 1970s, and said that is the cap that the fees can't exceed that. And in that case, that would have meant like a 40% increase over the previous year's fee. Was that?
It's creative. And probably what you had to do to meet the situation that you had. It really depends on the language in the documents whether that was a valid move. Again, we've had to get creative for some of our clients because without doing that, they would have been stuck with not being able to meet their obligations. So we've done that too for some clients.
It's worth looking at if you're stuck in a situation.
Yeah, and when we've done that, but oftentimes the documents will read that basically 10% from the prior year so it doesn't allow you to kind of do that reach back. But again, we've done that too. So sometimes you have to be creative and walk the line. Okay, so if you haven't run into it yet in your life as property management or in life in general, this big ugly word of fiduciary duty will be thrown in boards' faces often. It's often used, often misunderstood. Okay, everybody says, well, you've got a fiduciary duty to do this. Well, typically fiduciary duty is not the right word. When they're yelling at you as a manager, you've got a fiduciary obligation to do this. Typically it's it's not a fiduciary obligation, it's just a contract obligation. Fiduciary obligation means something different under the law. So it's a broad term that includes the duty of loyalty and the duty of ordinary care. So what do those things mean? So Maryland law defines duty of loyalty as basically it prohibits a board member from using their position to take unfair advantage of the association. Basically means put the association's interest first. The association's interest is paramount to everything else. So we all recognize that living in a community association, that as a board member, you care about your own property too, right? You're not just in it because you have nothing better to do with your time. Oftentimes people get on a board for one of two purposes. One is they want to make sure the property values stay up by keeping the community looking good. Or two, they had some interest in being on the board because they wanted their deck approved or something like that. I mean, that's the reality. Or three, people have an altruistic, good-natured purpose of just wanting to give back to the community that they live. I find that that's usually not the number one reason, but it's there. Once the food's ready, we'll take a break so you can grab your sandwiches too. But it basically means that when you act as a board member for your community, you're supposed to make a decision in the best interest of the association, not your own self-interest. You're supposed to have undivided loyalty. That basically means is don't favor one person or one type of situation over another. Gather the information you need to make a reasonable decision. Avoid conflicts of interest. Conflict of interest, believe it or not, can arise more often than you think in community associations. So if it's, Mel manages a community in which he lives, that's probably a conflict. Can't do it. Well, if you're a board member and you're serving on a board and you're and the community's looking to hire AW Landscaping, and Johnny, who sits on the board, is a manager at AW, it's probably a conflict. Now, what does that mean under the law? What it means is, at the very least, Johnny has to disclose that he's a manager at AW Landscaping. That's one of the contractors bidding on the project. But it doesn't necessarily mean he can't vote. Now, my advice would be, don't vote. Recuse yourself because there's an appearance of impropriety. But under the law, it doesn't actually say he has to recuse himself. It just says he has to disclose the conflict. Make everybody aware that that exists. I testified as an expert this past winter in a case in D.C. where the mother was on the board and her son, who actually, for a little while, a grown man, 20 years old, lived in the house, had his own landscape company. And the mother, who was the board president, got the son's company up for bid, and they hired the company. Now, everybody knew that it was her son's company, but the people feuding in the community sued, saying that was a conflict of interest. She should not have been able to hire the company. At the end of the day, the court said she had an obligation to disclose it. She did. She didn't actually have a pecuniary interest in the company. She wasn't getting a kickback or any benefit from being the mother of the owner of the company. And the court said it's not a conflict. It wasn't improper for her to do it. Now, again, I would say it's your son's company. Recuse yourself to avoid the appearance of impropriety. That's what she should have done. But the court held it wasn't a conflict for legal purposes, but he also commented probably not the best way to do it, but it's not illegal. So before I move on to the next part of our duty of ordinary care, why don't you grab sandwiches? Want to do that now? Because you're probably getting hungry. All right, let's take a break while you do that. And if everyone's okay with it, what I'll do is I'll keep jabbing while you're chewing. Does that work? All right. So, I don't know how they did it, but I'm sure somebody knows. All right. Gang's all here, at least most of us. So, all right. So, before I talk about duty of ordinary care, let me go step back. Somebody pointed out that I forgot to talk about the third insurance. So I talked about general liability, talked about directors and officers liability coverage, and the third type of insurance that's required is called fidelity insurance. And fidelity insurance is? You want to protect the money. Make sure nobody steals my money. So fidelity insurance says that in one of these worst case scenarios, if somebody tries to run off with the association's money, fidelity insurance is there to protect it and cover it. It's kind of like if everybody knows what FDIC insurance is at banks, if somebody steals the money from a bank, federal government insures it. Well, fidelity insurance is private insurance that protects the association's money. Now, it's there and good. You got to have it, and if you don't, association can really be in trouble. So, when does that happen? So, back, I told you before when we started, when I worked at a law firm between college and law school before I went into getting my law degree, when I was that law clerk, kind of gopher and paralegal, the very first case of its kind, at least in this area, came up when a company called Cameo, Property Management, which was based in Bethesda, the principal of the company ran off with millions of dollars of association's money. And you would have thought that fidelity insurance would have covered all those associations. Unfortunately, the way the policy was written at the time, the fidelity insurance covered officers, directors, agents, but it didn't cover principals of the agent. So when he ran off with the money, a lot of associations were stuck, lost lots of money. Good thing was he was caught. Bad thing was all the money was gone. Unfortunately, he ended up committing suicide, and then nobody knew where the rest of the money went. So that happened in 1992. So 92, that's about right, 92, 93. Fast forward about 10 years later, now I'm a practicing lawyer, something very similar happened again. Now the insurance policies were written a little bit better. Another company out of Virginia, the principal's son who worked at the company, ran off with a bunch of money. That one was really good for the news because it turned into a police chase and shootout. Kind of a crazy situation. So this world that you're now getting into, it can be very entertaining, if nothing else. But associations, again, have the fidelity insurance. Most of them recovered their money through the insurance. Some of them didn't because they didn't have the right kind of insurance. That's why insurance is very important. And then a couple of years ago, a guy around here, again, another situation where it came up, where property management company was kind of running as a sham. And basically, so one of the things to keep in mind is for fidelity insurance, which is my point of this last story, is that associations and their management companies have obligations to be careful with money. One of the things that you cannot do is what's called commingle funds. If you manage associations that you've got 5 associations, they've got 5 different reserve accounts, you can't put all that money in one account because you're supposed to keep it segregated. This company that a couple years ago that did this took everybody's money, threw it all in one account, decided to borrow against it to open up his management company new office, and then defaulted on the loan. The bank called the loan, and then the associations found out, and everybody woke up and said, no, that's our money. But he commingled the funds, and nobody knew whose money was what. So that case is actually still kind of going on a little bit in Baltimore. And it was a mess. So fidelity insurance is there, and in that situation, the insurance company for the associations under the fidelity policy is paying a lawyer to chase down the money to protect each association. The moral of this story is money is a messy thing, and that's why you have to have fidelity insurance to make sure nobody messes with it and protects the association at the end of the day. And the fidelity insurance covers actions all officers, directors, management companies, agents. Now the policies are written to cover principals. If you have a lawyer look at it, make sure it's set up right, or even if you don't, just something to be mindful of to make sure. There's lots of other stories where it wasn't managers. More often than not, it's actually the association officers in self-managed communities that are stealing money or doing things for their own self-interest. But those stories don't get a lot of press, so those weren't the ones that are out there that I could talk about. But those happen too. But that's why the fidelity insurance is there. So if you're an officer and director and you steal money, it violates your duty of ordinary care. It breaches your fiduciary obligations. So that's why the insurance is there. But let's talk about ordinary care. So boards must perform their duties in good faith in a manner they believe to be in the best interest of the association and with such care as an ordinary, prudent person in a similar position under similar circumstances. That's the legal definition. Jason's English version is, you got to be reasonable, do it right. Okay? So when you're on the board of a community association, what makes sense? Ordinary care is basically being reasonable with the decisions that you make and how you spend association money and in entering into agreements on behalf of associations. So what does that mean? That means if you're putting a contract out to bid to hire somebody for services, don't just send it to one guy and say, we want to replace the balconies, what's your price? And hire that guy. Ordinary care says, you got to bid it out. Get 3 bids. Shop the pricing. What makes sense? Check the reputation of the contractor. Does it make sense? Has he ever done it before? Or is he a guy that's usually doing landscaping work and now he's calling himself a roofer? Had that case last year, by the way. So ordinary care, due diligence, make sure that the boards are making the right decision. And it's your role as the manager, or once you get to this point of authority and power as a manager, is guide them. When the board wants to do something stupid, that's why you're there as a professional. Raise your hands. Wait a second, guys. Before you just hired Johnny, who's Sonia's son over there, to do the work, put it out to bid. And Sonia, if you're going to look to hire your son's company, you got to disclose it. So as the manager, you're kind of the eyes and the ears to protect the board from hurting the community and themselves. That doesn't mean you have a fiduciary obligation, but that's kind of the role that you serve as manager day to day, is to kind of prevent the board from doing harm to themselves. And remind them, you know, when they're applying to have their deck approved for the community, remind them, you know what, maybe you shouldn't be voting to approve your own deck. Recuse yourself and let the other people vote on it. Oh, okay, that makes sense. I mean, things that every day to you and I make sense, sometimes just people don't stop to think. So as the lawyer, sometimes I'm kind of the guy that says, hold on, guys. Let's check your practical meter at the door. Does this make sense to anybody? As the managers, you guys are typically there at every meeting. The lawyers aren't there. The accountants aren't there. And that's why you're kind of vested with this knowledge of what makes sense and what doesn't make sense. And again, you'll probably get guidance from your more senior managers that'll say, look, you know, it's a customer service business. You also don't want to piss off the client. So when you want to tell them they're being stupid, you don't say they're being stupid. You just might want to remind them, you guys might want to think about this. So I was talking before how this is really a customer service business of what we do, and it absolutely is. But it also involves sometimes millions of dollars worth of investments in properties. So you do have to keep that in mind as you're working with these communities, that it is a business. These board members are there to run a business and get the guidance from you as the managers, and again, be professional. So what happens if a board does it wrong? You might want to understand what happens. So there's something called the business judgment rule, which basically was first espoused in a case called Black versus Fox Hills North. And what that basically says is, look, associations are just like corporations. A board gets elected by the membership. Somebody's got faith in those people that they should know what they're doing, or at least know who to go to as professionals to make the right decisions. And so the court says, look, a group of 5 board members of a community that's elected by the membership, that is out there doing this day to day for their community, they probably in most situations have a better idea of how to do things than I do as a judge sitting up in a court second guessing or Monday morning quarterbacking, whatever you want to call it, a decision that they made yesterday or 2 years ago. So the courts say, look, when it comes to decisions of a corporate body or an association that's unincorporated, that's acting like a corporation, we're going to defer to the board's judgment. And we're going to say that under the business judgment rule, the court's going to defer to business decisions made by the board of directors so long as they did not act in bad faith or with criminal intent. So let me give you the examples because that's a better way to understand it. So Black versus Fox Hills North. So that situation was the board decided to approve a fence. They approved a fence that was 60 inches high. And Mr. and Mrs. Black, who lived next door, said, I don't like the Cooper Smith's fence. It's 60 inches, it's board on board, it's ugly, and I think the board was wrong in saying it's okay. They should not have approved it. And so they sued. And they sued the Cooper Smiths, and they sued the board. And they sued the association saying you should have never approved that fence. Court reviewed it and said, look, the board of directors had the authority in the documents. The board of directors has the authority, acting through their committee. In this situation, the board was acting as a committee. They may or may not approve architectural modifications on a property. Common provision in documents. The board said they looked at it, they reviewed it through their regular process. They got an application, they saw it, they approved it. The guys, Cooper Smith, built their fence. They didn't do anything wrong, they got the approval. And the court looked at it and said, you know what, Mr. and Mrs. Black? There's a process called for in their documents. They followed their process. They exercised their discretion and they said, you know what, we're going to approve the fence. And we as a court looking at the fence, we think it's ugly too. But you know what? It's your business decision to make whether to approve or disapprove fences in your community. So we're not going to substitute our judgment for yours. And the court said, subject to what in corporate terms at the time was called the business judgment rule, we're going to defer the decision of the board, and we're not going to award the Blacks any ruling in their favor in this case. We're going to defer and say, you know what, board? You had the right to make that call and that decision. The court even in a footnote said, oh, and by the way, they got it wrong. Their document said you can't have a fence in excess of 48 inches, and they let it be 60. But the Cooper Smiths did nothing wrong. They followed the process. The board made a mistake in approving it, but even though they made a mistake, it was a mistake made in good faith. There was no ill intent, no criminal intent. They were just simply negligent. They were dumb. They made the wrong decision. But the court said it stands. And that decision, what's called the business judgment rule, has been upheld time and time again in Maryland, and even in 2 cases in the last couple of years where, one, it was a roofing case where the board said, we only allow these types of roofs, and they denied somebody the right to put on, in this, it was a high-end community, this is actually Avenel again. Avenel community on Potomac. Out there, you can't have just a plain old asphalt roof like you and I have probably on our homes. There it has to be cedar shake or slate because of the aesthetics of that community. And they said no asphalt. So Mr. Reiner sued, said, I want asphalt. Board told me no. Actually, the committee told him no. The board of directors on appeal told him no. So we sued. Went all the way up to the Court of Special Appeals in Maryland, and a published decision said the board's business judgment decision controls. They say they don't like asphalt. Who are we to second guess it for that community? So business judgment decision controls. Why is that important? When you're acting as a manager for your communities and working with them, remind them to follow the process that they have in their documents. What the courts have said, if you go through your process, that's reasonable. That's what an ordinary prudent person would do. But it doesn't mean ignore your documents. Don't ignore the process. You have to go through it. if your documents call for an application, architectural application, and a review by a committee, and then the committee reviews and approves or denies it based upon standards, that's the process. But if Johnny shows up with his deck application, I keep picking on Johnny. Johnny shows up with his deck application and says, I want to build this deck, and the manager or the board says, yeah, okay, go ahead. Don't go through your process. There's no record of it, and they just build it. That may not be something reasonable. That may be something that you want to be doing because you're not following a process. The other case that was recently reviewed, the business judgment decision, was it was actually a secondhand smoke case for Greenbelt Homes, which is a co-op over in Greenbelt, Maryland. And that, there's a lot of issues in that case about secondhand smoke, but what came out of it with respect to business judgment decision, the court, and then on appeal, the court looked at, well, there's a process for enforcement. Did they follow it? Did the board give everything due consideration? There's an enforcement policy and a process that called for a hearing, a right to be heard, due process. Court said they went through all that, and they found there was no violation, and therefore didn't throw the smoke right out of the complex. Court said, you know what? They followed their process. They did it right, and business judgment decision they upheld. But what you can read into that is, had the board not followed their documents in the process, may have gotten a different result. So Mel, did you have a question?
Well, on that case, the Black case, did they make the board and the courts aware that these people had built the fence not in compliance with the regulations?
They did. So the real issue in Black, it gets complicated, but it's a pipe stem lot. So the lot, so basically the house is built like this, and the other property is behind it, and it's set back. And basically what the document said is you can't build a 6-foot fence forward of the front building line.
I see.
And so for these people, what it means is you can't have a fence in front of the house.
Right.
But over here, these guys were arguing, well, it's in front of my building line. And therefore, and they argued it was restricted to 48 inches. So
the documents were written for their building, for the unit owners.
Right, so basically the way the documents were written, it was being interpreted that it didn't apply on pipe stems the way it was being read by the blacks.
I can understand that. I just thought it was a simple.
Yeah, no, it was a little bit more complicated. But the point of it, again, was the court said how they were interpreting their documents, we were going to defer to them. So, again, you can't let boards be stupid, ignore their process, and if they try to be stupid, I think it's your role as a manager to at least wave the flag and say, hey guys, remind you got to do this. Now, you're protected though under your contract. I've read Mel's contract that he has with his communities, and it says, even if boards are stupid, you're not on the hook. But again,
actually, it's in the old print.
Right. but again, that's part of your role as manager is to save boards from doing stupid things. Again, so what is ordinary care? Again, this is a process again. Boards, this is really more for board members, but again, as manager, you should be familiar with it too. Board members should not miss a series of meetings. They need to be familiar with the issues, know how to read a financial statement, stay informed of committee activities. Again, as a manager, you certainly need to know how to do these things. And get educated. You're here with me today, that's part of it. You'll work with more senior managers to understand how to read a financial statement, for those that don't. And board members are always concerned about liability. And just so you have an understanding of this, board members in Maryland cannot be held personally liable for decisions that they make by sitting on a board of a community association that they do on a voluntary basis, so long as a couple things exist. And this is under statutory law. One is have D&O insurance. That's one protection. The law says a board member can't be sued as an individual. Again, that Avenel roofing case, another component of that was Mr. and Mrs. Reiner sued not the association alone, but 14 members individually of that community. It was a 9-member board plus 5 members of the committee that denied their application. Name them all personally. So the Reiner case isn't Reiner versus Avenel because they sued Cliff Ehrlich, who was the board president, and they named him first in the lawsuit. wasn't very nice, and also violated the law. Because of the statute that says, even if you want to sue an association for a decision you thought was wrong by the board members, you're supposed to name the association as the defendant, not the individual board members. So Mr. and Mrs. Reiner didn't listen to what the law said, nor did their lawyer, Mr. King, who, by the way, was their neighbor and lived in the same community. And they sued those 14 individuals in the community. So what does the court do? If ultimately the judge yelled at Mr. and Mrs. Reiner, yelled at Mr. King for filing that lawsuit against them the way they did, and because the lawyer asked the court to award sanctions against them for doing that in violation of law, the court did, made them pay all the attorney's fees. So that's justice in some sense. But why is that important? Because when you go to a board meeting, or when you go to an annual meeting and people are being elected, and somebody comes up to you and pulls you on your sleeve and says, look, kid, do I have anything to worry about in terms of me getting sued or individual liability? Your first answer is, well, you know what, you need to talk to the association's lawyer if you want the true answer. But as a board member, what you need to understand is there's D&O insurance that protects you. There's the law that says you can't or shouldn't be sued as an individual. And the association documents also in their bylaws say if a board member gets sued for their actions they make in the scope of their duties, the association has to indemnify them, which basically means pay their attorney's fees and any potential liability. So they have protection 3 ways from Sunday from if they've sued. When can a board member be held personally responsible? It's somewhat of a practical situation. Is one, if they're criminal, they do something in violation of the law. I've seen that, where the insurance company said, that was criminal. We'll pay for the lawyer to defend you, but if it's found that you were actually criminal in what you did, criminal intent, it's all on you. So if the boards are making decisions with criminal intent or self-dealing, and really what the language says is if they make a decision in bad faith. So criminal and bad faith. What's bad faith? Well, the judges in their infinite wisdom in Maryland have said bad faith is anything but good faith. Kind of like the old adage, pornography is you know it when you see it, as the old case says. So what does that mean? I think it's practical. If boards are following a process, being reasonable, making decisions, and not doing things to basically put money in their own pocket, directly into their own pocket, stealing money, skimming off the top, they're probably going to be protected. So role of the manager. Okay, this is a little bit of the meat of it. And before I get into this, because Ron asked me to at least mention it, I want to talk about, for a minute before I get into this, is cooperatives. So we've talked about condos, we've talked about HOAs. What is this thing called a cooperative? And I think you have like 2 or 3 that you guys work with here. I represent a number of cooperatives as well. Greenbelt Homes being one, which is the largest in Maryland. That was complicated. And I represent the Promenade, which is a high-rise in Maryland. So there's not a lot of co-ops in Maryland anymore. There's a handful of them out there. DC, we find it more often. I represent a bunch in DC. And so you need to understand, before you understand your role as a manager as well, as what these different types of organizations are. So I explained a condo is where people own the individual units, and fee simple is what it's called. They own the box, the square, what's inside the walls in the unit. So like if this was a condo unit, nice size, basically everything from the walls in typically is going to be my own space. I own the unit, I own the floor, I own the ceiling. I may not own the studs above it, that may be a general common element, but I own the drop ceiling tiles. In an HOA, I own this whole building, right? And the land that I'm on, okay? In a cooperative, what do I own? Paper. I own paper. I own a paper that's basically like stock certificate that says I own a share. I own a piece of the entity that owns this whole place. So I'm like a stockholder. And in cooperative documents, you're called a shareholder. And what do you own? You own the right to occupy this space. Nothing physical, the right to occupy this space. So basically, it's like renting. really cooperative is like a rental interest. And the courts have held that a cooperative association, basically because it's so similar to a landlord-tenant relationship and the rental property, the owner of a co-op, the cooperative association, basically for all intents and purposes, has the same obligations as the landlord does to the tenant in maintaining the property. That means has to be habitable, basically has to be livable. You have to make sure the property is well maintained. Now, under most cooperative documents, even though I just own this space, I'm responsible to maintain, repair, and replace the components that serve my space. Sometimes the toilet, sometimes the sink, sometimes the dishwasher, the refrigerator, all those things, where in a rental property, the landlord's got to replace. Depends on the documents. Some co-ops basically put the onus on the association to basically take care of everything. The dishwasher, the microwave, the stove, if it's a fixture in the unit. Most cooperatives that I work with is a hybrid. The appliances in the unit are individual responsibility, but the pipes serving the unit are the association's responsibility. So in a co-op, you get all different types of provisions in the documents about who's responsible for what. In a co-op, a couple things to keep in mind. There's a set of bylaws. All co-ops, in my experience, are corporations. I haven't yet run across an unincorporated cooperative association because they want that corporate protection. So the corporation, like any other corporation, has a set of bylaws. That's the meat. That's the main document for a co-op, is what's in the bylaws. And then within the association, when you buy into it, there's basically a sales agreement, like when you buy a piece of property, but it's more like a lease. It reads like a lease. You have the right to own and occupy the space. Here are the terms. The difference is, though, there's typically no end date. It's not like you lease it for X number of years or you own it for X number of years. You can own that cooperative share in perpetuity forever until you decide to sell it. Some cooperatives have provisions that say, I can't sell my shares, the right to occupy this space, to someone else without the board approving the purchaser. You get that a lot in D.C., in New York. If anyone ever lived in a co-op in New York, you have to go to a meeting and sit down with the board as a potential buyer so they can bless you as somebody that's deemed okay to live in their building. It's a very funny concept because the co-ops that have those provisions, they'll do a credit check, criminal background check, they'll check, whether you've been nice to your dog. I mean, they ask all kinds of crazy questions, and they can get away with it because their documents allow for it. Now, most cooperatives modern day today that exist, they don't go through that whole interview process, but they do vet the financial stability of somebody. They can limit who you can get financing through and how much you can finance. Some cooperative documents say you can't finance more than 70%, which means you have to have 30% down to buy, which is higher than buying into a condo typically, which can be 10 or 20%. So they can put some pretty onerous standards because their documents give them such broad authority. Also in a co-op, who has the decision-making authority? For most decisions, it's vested in the board, like a corporation. They rule the day. The buck stops with them and they make all the decisions. There's limited things that the shareholders get to vote on, but when it comes to the major decisions, the board gets to make those decisions and they get that power. Other things to keep in mind with the co-op when it comes to what's generally referred to as the common areas, like the landscaping, the things outside the building. Typically, owners don't have any say at all. It's completely vested in the decision-making of the board. And the way that the stockholders, the cooperative owners, have a say, you get to vote for who you elect. And that's kind of the process. It's more of a democratic process where everything's deferred. Typically, and this is more of a practical, cooperative assessment or the equivalent of assessment payments are higher because you're paying to support not just the common areas, but the infrastructure components. Oftentimes utilities or some utilities are included in those payments. You're paying for insurance. Oftentimes cooperatives have management on site, if it's one of the larger ones, that have its own basically personnel that are hired to run it. In terms of maintenance and repair, typically the co-op's left with the headache of everything. Like I said, lots to do in terms of maintenance, repair, replacements. And again, because it's looked at as like a landlord-tenant relationship, courts basically put a higher standard on those obligations to make sure the properties are being maintained, that they're habitable, where in an HOA or a condo, some things fall back on the individual unit owners. Co-ops can be complicated because of the different types of relationships that exist. I know Charlene has worked with co-ops before. Her and I have worked on, I don't know if you still even do Windsor Square, but you say you do, you
We
don't.
only have one, and it's what, 12 units?
Yeah.
Well,
Yeah, so
Yeah.
like that.
But they're their own entity.
Yeah.
Well, when I worked with Genarch, Greenbelt uses Genarch,
Yeah.
and I was like, please, someone give me that. I don't want to be their account manager. Please don't, no.
Yeah.
Because they are very complicated,
Yeah.
very
And
complicated.
and that one has
And it's huge,
yeah, it's huge. It's the largest in Maryland,
yeah.
and it's also has different types. It's talking about masters with subs. It's a co-op that has all different types of stuff going on in there.
The
So
way they do their accounting is just out of the norm too, so,
co-ops can be a headache.
yeah.
So let's talk about the role of the manager. So management contract. What's your relationship with your association? It's all set out in the management contract. If you're a manager of an association that has never read your management contract, you should. Because dollars to donuts, if a board has a problem with you, they're going to yell at you about, your contract says this. And the worst position you want to be in is say, I don't know what the contract says. Mel signed it with him. I don't know what it says. So as you go through this business, read the management contract. And the management contracts change over the years. I'm stuck with a contract entered by my partner who passed away a couple of years ago with a monthly retainer of $150 a month. Okay. I couldn't sneeze for $150 a month to review contracts that he wants me to review, part of that retainer. So, as one of my newer partners said to me, we got to get rid of that. But your management contracts change over the years. So my point is, even if you're signing a new contract today, but you've got a community that's been with Mel for 30 years or 20 years or what have you, make sure you read the contract that's in place to understand what your obligations are as a manager. Don't just rely on the manager before you to tell you. They probably know 90%, but people don't always remember everything. So read the contract. What is your obligation? You have to provide a monthly management report X number of days before the meeting. Some contracts provide that specifically because the old board negotiated it with Mel years ago that you would get the package 7 days before the meeting. Are you required to give financial statements? If so, how much? What are you supposed to be giving? What's your role as the manager? Are you supposed to be driving through the community once a week to check for violations, or is that left to somebody else? Read the contract. You're an agent. You're not an employee of the association. What does that mean? Well, from a legal standpoint, you're called an independent contractor, which means that you don't have an employee-employer relationship. There is some separation there. It protects you, it protects them. It also means you can be hired and fired pursuant to the terms of the contract. You'll never get fired because you're going to do great things. But keep in mind that the management contracts that you enter also are supposed to comply with the association's governing documents. Now, it's really the board or the board's attorney, when they actually call me before they enter a contract, to make sure that they're not violating their documents when they enter into a management contract or any other contract. So a lot of association documents have provisions that say associations can hire professional management, enter a management contract, but the contract can't be longer than a year and has to be able to be terminated, terminable is the word in the documents, with a 30-day notice. How many times does an association have me look at a management contract that says it's a 3-year contract and it can't be terminated on less than 90 days notice with cause? Happens all the time. But again, the association board should be looking at their own documents. it's been argued that if a management company in professional management services enters a contract that violates the documents, that the contract may be voidable on those terms because the management company kind of did something they shouldn't have done.
But typically, we don't have access to the documents at that time.
Right, which means the board shouldn't be entering into contracts.
Correct.
Right, which is why they should be checking with their lawyer. But they don't, because they do it cheaply. Right? There's a cost of that. And again, just from the management side, again, be familiar with the documents. What's your relationship of the manager to the board members? Again, I've talked throughout this about kind of you're supposed to be the professional, supposed to remind the board of their obligations. You're not obligated to, but from a practical standpoint, that's why you're there. That's how you retain clients. That's how you get new clients. Because Carol, Charlene, Ron, people have been doing this for years, do right by their boards. And the managers that I work with that do right by their boards are ones that stick around for years and years. Because boards change, but if the manager's there for a long time, you guys learn the history of the community, you know what's going on, you guide the boards. You don't tell them what to do, but you guide them to hopefully make the right decisions. You build that relationship. Again, I keep talking about how this is a customer service business. It really is. I like doing this because I like dealing with people rather than sit behind a desk doing tax law all day. But as a manager, you're going to see the good, the bad, and the ugly of people. You're going to see the good of people who are really doing this for the right reasons to help the community, even if it's to help their property values. You're going to see the bad. You're going to see the people that violate. Sometimes you're going to run into criminal activity in the community. And the ugly, which is really ugly, is when people stand up at a meeting and point their finger at you, the manager, and tell you, you're messing up, you're doing this wrong, it's your fault that this and this and that. Don't take it personally. Have a thick skin. My practical advice to you. Because it's not personal, it's business. And people take everything personally. I have a firm that next to me is our domestic group, our family law group, and we compare notes who has the worst clients. Is it the associations with the ranting and raving homeowners that yell and scream all day? Hopefully, typically not the board members. Or is it the domestic relations, the family law people that have the estranged spouse on the other side of a case yelling and screaming about something? It comes pretty close sometimes. Because family is very personal. It comes right to the heart of everything. But so is property. And so people, when it comes to their house, some of these communities, I work with people that have worked at the White House. But when it comes to what color fence they have or what their neighbors are doing, you wouldn't know that they're in a professional world at all the way they act. It's amazing. So can't take it personal, but be professional. And also in guiding your boards, when people show up to meetings and they yell and scream at the board, you try to remind the board too not to yell and scream back. They don't always listen. I have a case now where a board member who yelled and screamed back things he shouldn't have said resulted in a fair housing complaint for discrimination. So now the association is forced to cough up some money because of the board president who was a bad actor and shut off his mouth when he shouldn't have. Now they threw him off the board the next month and convinced him to resign, but that was after the damage was done. And by the way, yeah, the owner was a nut and deserved every rant that he got, but because the board member threw in some words he shouldn't have, that's what got him in trouble. What else? What other relationships do you have? You have relationships with vendors and contractors on behalf of the association. As Mel and I talked about earlier, you're not contracting with them. You're helping the association hire these people. And again, you help them by saying, let's get 3 bids. Let's review the bids. Let's make a decision. Doesn't mean always to go with the cheapest bid. If it's ABC fencing company who's got a horrible reputation, they might be the cheapest, but they might not be the best for what the community needs. Again, your experience will help guide them with that. Ultimately, don't make the decision for them as managers. Don't tell them who to hire. I don't know if Mel will disagree with me, but I think your role as manager is get them the bids, present the bids. You can certainly give guidance in terms of your experience with the contractors, but ultimately it's the board's decision. Don't sign the contract on their behalf. Let them sign it. Don't tell them who to hire. And certainly you can relay, again, your experiences with them, and you can guide them to what you think the best decision is, but don't tell them what to do. In terms of the other professionals that you work with, again, you work with the lawyers, that's obvious. You work with CPAs who are accountants that will do audits. Again, being familiar with your documents, a lot of condo documents, the older ones, require actually associations to get an audit done every year. Some documents say should or may instead of shall. Be familiar with the documents, understand whether there is an annual audit requirement. And as just from a practice standpoint, if you're a manager or a management company taking over for somebody else that managed the property before you, I always recommend as a lawyer, and Mel probably encourages this as well, I would believe, that the association should have an audit done of the books coming from the prior management company. That way you don't get stuck with what the guys before you might have messed up. Other things to be, again, aware of. So, board meetings. You got to make sure that the boards are prepared and that you're prepared. There should be a management package. One, this is a way to report to the boards how awesome you guys are as managers. Show them what you've been doing. It's not just you show up at a meeting every month and talk to them, but all this activity happens between meetings that you do for them. So the management package should be presented to them professionally, should be comprehensive, should show them what you've been working on, should give a report at the very least, if not copies of letters and documents that you've sent out. An effective board meeting needs to be well planned. Again, as a manager, help them plan it well. It's also the difference between you spending 2 hours in a meeting or 5 hours in a meeting. If you help the board be prepared for their meetings, you'll be in and out of there quicker. The worst thing that you can do as a manager is get stuck in a meeting for 5-6 hours. Probably everyone that's done this job for a long time has been stuck in those meetings. Sometimes you control it, oftentimes you don't, but the best thing you can do is help them be prepared for it. Make sure they have an agenda prepared ahead of time. Again, in terms of the agenda of meetings, again, a lot of you are new to this. So what can you expect when you go to a meeting? Well, at a board meeting, there's certain things that need to happen or that should be happening. One is the meeting needs to be called to order. Do we have a quorum of the board? As a manager, look around the room. Do I have the majority of the board members here? If not, tell them, hey guys, we'll wait for a quorum before we can start doing anything. Make sure there's an agenda prepared ahead of time. Some boards have the manager help create the agenda. Other boards, the board president does it and presents it to the manager to disseminate to everybody else that's on the board. Any question?
Is there a legal minimum to the number of people that can be there for the board? For example, one of the communities I've taken on has 7 theoretical board spots, but 2 are currently filled.
Okay. So the governing documents will say how many board members the community can have or should be having. So oftentimes the documents will say a minimum of 3, but no more than 7, no more than 9, depending on the documents. But there's already been an established number that's been in place for a while, typically when you guys show up or take over. If the board is supposed to have a 7-member board, but you've only got two sitting people, you got problems. Okay. A board that's supposed to have a 7 should have a minimum of 4. So, but if you only have 2 and everybody else resigned, 2 of 2 is enough to conduct business in that situation. But you've got to move quick to get other people appointed to fill those slots. The other practical thing you can do is at the next annual meeting is typically where the board in the documents has the power to expand or contract the number of board members. So if you've got a community that can have up 3 to 7, you've had 7, you're now down to 2, have the community vote to drop it to 3, so at least you can get some business done without that headache. So make sure you have the quorum. It should be a given, but a double check also is, if you don't have the quorum, wait a second, guys, did notice get to everybody about our board meeting? Because one of the things that's also supposed to happen is notice of board meetings is supposed to go out to the board members. Now, if it's a regular meeting of the board, oftentimes the board's process will be, we put it in the newsletter every month. It's on the website. We post signs in the community that says, our meetings are the second Tuesday of every month at the community center next to the pool at this address, 7 o'clock. You've given notice to everybody. Everybody's aware of it. I'm going to talk about the statutory provisions in a moment, but as a general rule of thumb, all meetings of a board of directors, except it falls into a limited set of what's called executive or closed session meetings, are supposed to be open to the public. Open to the membership, not the public. Open to the members of your community or the owners. How do they get notice about it? Well, the statute says you have to give them notice. How is notice provided? Well, the statute says reasonably. What is reasonable notice? If you've got a newsletter, throw it in the newsletter. If you've got a website, reasonable notice may be put on the website. The best thing to do is at least annually send out something that says when the board meetings are typically held. Some communities that still use coupons, oftentimes we're getting away from those now. But if they have coupons, sometimes they print them right on the coupon. Board meetings are held the second Tuesday of every month at the community center. That's reasonable notice. For people to be able to attend the meeting, they have to know when it is and where it is. And the law requires that you give them that notice. The documents will require notice to board members be a minimum of 72 hours typically before the meeting. In the bylaws, it'll say that. Your role, again, as manager, make sure that the board members get a reminder email as my practical. If you've got a problem with a board where people don't show up sometimes because they forget, put it on your thing a couple days before the meeting, send a reminder. Hey guys, reminder, we're meeting this Thursday at 7 o'clock. See you there. Again, most boards, are good board members, they'll have it on their calendar or they regularly show up. But if, practically speaking, if you're having problems with some board members forgetting, you want to make sure you take care of that. Make sure the financial reports are in there. Committee reports. If it's a larger community that has committees, remind your committee chairs to get you an update or report on what the activity is. Management reports, again, the activity that you've been doing. Special reports, memos, correspondence. Special reports is sometimes there's a big renovation project going on. So you'll have an update from your engineer on the status or the progress of that. Give the board the update. Boards should be familiar with their governing documents. If they're not, make sure that you get them what they need. Yes?
In reference to closed meetings, you are allowed to have closed meetings, right? As long as you're discussing delinquencies?
There's a specific list we're going to talk about in just a minute.
Oh, okay.
That's okay. Couple other things to be mindful of. You have to contact the meeting participants and provide adequate notice. If you're a condo, if you're an HOA, and now in Maryland, because they changed the law, a co-op, notice of meetings has to be posted. Now, what is a meeting, or whose meeting that you have to give notice of? Well, everybody knows a board of directors is part of the group that's meeting that you have to give notice of. Sometimes people forget that the statute says a meeting of the governing body. Well, governing body in the statute is defined to include committees as well. So a committee of the board, covenants committee, architectural committee, budget committee, if they're meeting, one, it's got to be noticed, has to be open to other members of the community to come and listen to, and they've got to know time, place, and date of when it's happening. I see communities all the time that don't do that. They just kind of just get the notice out for the board meetings, but don't do anything with committees. The law requires the committees also be opened and noticed to the community. Develop an agenda. I've thrown in the package, and it's up here, just a sample basic agenda of a board meeting. Again, call meeting to order, establish a quorum, read or review the prior meeting minutes. A good community manager will harass whoever's taking the minutes to remind them to get the minutes done, unless you as a manager, part of your role is keeping minutes for the meetings. Officers' reports. Again, this is assuming that your community goes through all this every month. Is there a president report, vice president report, treasurer report, secretary report? Typically at a monthly board meeting, you're not going through all of this, but at least the opportunity could be there, should be there. Are there committee reports? Old business, new business. I always say leave an executive session if necessary on your agenda. That way, because typically boards will meet in open session and then throw everybody out into their closed session, which we'll talk about in a minute. Or you excuse people that are not part of the board for that. And you can adjourn into executive session. Annual meetings. Let me talk about that for a minute, and then we'll talk about the open and closed meeting distinctions. Election of board members is typically the main purpose and function of the annual meeting on the governing documents. Elect the board. Just as a caveat, some associations, condominiums, the annual meeting reference in the bylaws sometimes couples the budget adoption with that. Oftentimes it's separate, but check the documents. I have some communities where they vote the board and adopt the budget at the same meeting. It's kind of stupid, but some of the older documents have that. Notice of meeting. Again, there's very specific requirements. I'm not going to get into all the intricacies now because there's a lot of nuances to it, but be mindful of a couple things. One is HOAs. The HOA Act of Maryland, I've given you some provisions in the handouts and the documents there, but the HOA Act is not as specific as a condo act in many respects. So when it comes to checking the statutes or checking with the lawyer about the statutes, and my website, I have links to the Condo Act, the HOA Act, the Residential Cooperative Act. Not that I want you guys to be the lawyers, but at least familiar with kind of what these things look like. But the HOA Act is probably only about 30 pages as compared with the Condo Act, that's probably 70 in terms of the material that's there. Condos have all these specific provisions that they deal with. Notice of meetings, proxies, ballots, elections, resale documents, all those types of things. HOA Act is very, very much smaller. So where the election of boards is dealt with in the Condo Act, that oftentimes has to be read in conjunction with the bylaws, the HOA Act is silent, so the documents control. When it comes to proxies, the HOA Act is silent. The Condo Act has very specific provisions about proxies that control. The exception is Montgomery County. Montgomery County, if you've got a property in Montgomery County, it's subject to Article 10B of the Montgomery County Code, which has very specific provisions that apply to HOAs and condos with respect to meetings, the right to go to the CCOC, which I'll talk about when we talk about enforcement, and some other provisions with respect to how HOAs govern. But other than Montgomery County, the laws in most counties are silent, or all the other counties in Maryland at least, are silent on HOA governance issues. But the Condo Act is very specific. So annual meetings, there's very specific notice requirements for condos and how things work. So for elections in condos, keep in mind this. So it's very complicated. So for a board meeting, for an election at an annual meeting, 45 days before the notice of the annual meeting goes out, okay, and a notice of an annual meeting typically has to be sent no more than 10, no less than 90 days under your bylaws to the membership about when the meeting is going to be. 45 days before that notice is going to go out, you have to send out, for a condo, a call for nominations that says, we're having a board election. There's 2 open seats. If you're interested in running, submit your name for consideration to the board for the nominating committee, and we can put your name on the proxy ballot that's going to go out with the notice of annual meeting. 45 days before the notice. What does that mean as a manager? If you have an association that's a condo, calendar for yourselves when that is, so that you have a tickler to remind you. Because let's assume for the sake of discussion you've got an October meeting for an annual meeting, which is very common. Well, you're going to send out, in a perfect world, 30 days before the annual meeting. So let's just say it's October 1. So September 1, you're going to send out the notice of annual meeting for the October 1 meeting. Well, 45 days before that, so let's see, August, September, so the middle of July, you've got to be sending out the call for nominations. Who thinks about that? It's summer. You're out at the beach. You're not thinking about this stuff. Put it on your calendar. Or if you're a manager, make your assistant do it, right? To make sure the notice gets out. And the call for nominations is basically trying to make sure that you get enough people to run for election for your boards. Oftentimes board members will just keep running year after year, but you've got an obligation to send out that call for nomination to gain the interest. And then it says, you make it more complicated, so you send it out 45 days before. And if you get a nomination 10 days before the notice, you can include any of those people, like put their names in the notice of meeting that is going to go out. And you can list them in alphabetical order without showing a preference for who you want to be elected. So now that you sent out the call for nominations, you get 3 people back that's going to run for 2 slots. All right, great. I'm putting the notice together. Well, I've got these 3 names, and I got them at least 10 days before the notice is going out, so I can put their names on the proxy ballot that I'm going to mail out to everybody with a notice of meeting. But they have to be alphabetical order, and I can't list them with a preference of who I want to suggest that they elect. So that means you can't on the proxy ballot say incumbent, existing board member, rerunning, star their name, bold, highlight, leave the other names not bold and highlighted. Can't show a preference at all. It's supposed to be a clean, democratic process. That's the way the cookie crumbles in condo world. Now, if you didn't get a name, you got a 4th name that came in the day before the notice is going out, the Condo Act says you're not supposed to include them. They didn't get their name in on time. Stick to the deadlines that you put in your notice. So again, condos with respect to elections, very intricate, very complicated. It's an easy process once you get the forms down, but as somebody new to the industry, it's a headache. So just be careful about that. 9 times out of 10, if you mess up a day here and there, nobody's going to care, practically speaking, unless you live in Thayer Towers condominium in Montgomery County, where if you miss anything by a day, you have this one homeowner that'll sue you and take you to court over.
Can other people put your name in nomination?
What's that?
Can other people put your name in nomination on that?
So, yes and no.
We had a board member who suggests that because the person is overseas serving the military, without really any indication that there's been confirmation from that person that he wants to put her name and his name on that.
So basically under corporate law, at some points they have to accept the nomination to be considered. Under Robert's Rules of Order, technically they don't have to accept it, but if they run and they win, they then have to agree to serve. So that's why, from a practical standpoint, I say, look, you got to get confirmation that the person's interested, even if it's an email saying, yeah, I agree to be considered, because you don't want people being elected and they don't show up, and then you got those headaches.
Yeah. And from a practical application, I don't think
there's nothing legally that stops it.
To stop them from doing that.
Correct. Unless some bylaws though do say the person has to accept the nomination, but it's rare that the specific language is in there like that. The one other thing I want to mention about condos in Maryland, you also have to announce at the meeting whether anybody wants to be considered from the floor of the meeting. What that language means is basically, let's say this was our annual meeting. I've got the 3 names. It's Jason, Charlene, and Mel are running for the 2 slots. I say, as the person running the meeting, is there anyone else that's interested in being nominated from the floor? Meaning somebody here at the meeting stands up and say, yes, I want to be considered. Now your name has to be added to the list for voting. Maryland requires for condos that you do that. HOAs, it's not required, but typically people do it anyway because the documents may say so. So again, just be careful of that. And annual meetings are required to have ballots for purposes of election. From a practical standpoint, proxies are not required necessarily, but they make sense to do it. What does a proxy do? Basically, a proxy is if I can't be at the meeting, I want to send in a piece of paper that says, I'm not there, but count me towards quorum. Because without meeting the quorum requirements, which is anywhere usually from 10% to sometimes 50% of the membership to be able to hold a meeting, a membership meeting, you can't do anything. You can't have an election. You can't get business done. And then it just keeps getting worse and worse. So when you send out your notice of annual meeting, you typically send a proxy ballot. Typically it's in a form that's either been drafted or at least approved by the lawyer for the community to make sure it dots the I's and crosses the T's with respect to what proxies have to say. In Maryland, you can get creative as well, because under either the corporate law or the condo law, let's say your document said 50% of the community is required for purposes of meeting quorum. Well, the Condo Act says, but if they can't get quorum, as long as you include this blurb, and it's a blurb that I've given to everybody here at some point or another, if you show up at the annual meeting, the first try, and you don't meet 50%, you can have a recalled meeting, and whoever shows up, even if it's 2 people, that's enough to meet a quorum for purposes of conducting business. So it's basically a Hail Mary in the Condo Act that allows you to do that. The other thing is in the corporate article, if it's an HOA, it's an incorporated association, the corporate article has a similar provision. It's a little bit different. The notice is a little bit different for the second meeting. It's supposed to be published in a newspaper of general circulation in the community. The Condo Act basically allows you to send it to the same method that you use for regular mailings. If you rely on the corporate article, you have to publish it in the newspaper, which can be expensive and stupid, but that's what the law says. You had a question?
That provision does not allow you to hold the reconvene that same night, correct?
Depends who you ask.
That
So-
information came from.
So let me talk about the dichotomy in the legal world of opinions on this. So Jason got creative a number of years ago when this law came out and said they drafted the statute wrong. It doesn't say what they meant to say. So what it says is you can have that recalled meeting and whoever shows up at the second meeting meets a quorum. And it says that notice of the recalled meeting has to be sent at least 10 days before the meeting. Okay. It doesn't say you can't put the date and time of the recalled meeting in the original notice. That's not what was intended. I know that. And every board I've given an opinion to on this says, this is subject to challenge because of this. But to save money, time, and expense, you can be creative. And in your original notice of annual meeting say, notice of annual meeting to be held on July 1st, 7 p.m. In the event that we don't meet a quorum at that meeting on July 1st at 7 p.m., pursuant to 11-109.1 of the Maryland Condominium Act, the board may, those present in person or proxy, may vote to schedule a recalled meeting on July 1st at 7:30. And whoever shows up at 7:30 constitutes a quorum for purposes of conducting business. Now, it met the 10-day notice requirement for that recalled meeting. It had the quotation of the statute. It's certainly not what the legislature intended, but they screwed it up by drafting it wrong. So, being creative, you can try Jason's creative way that, yes, is subject to challenge, but to date, nobody's ever challenged it. What that means is a board gets their meeting on the same night, gets the business done, no harm, no foul, because communities where that's an issue, there's apathy anyway, that's why nobody's showing up at 7 o'clock. But Craig Zauer, or Michael Nagel, depending on which guy you talk to, and a bunch of other lawyers say that, well, that's not what they intended, so the safer way to go is don't take a chance on being challenged, and basically have your meeting July 1 at 7 o'clock. July 2nd, send out a new notice for July 15th. Let's all show up again and go through the charade and do it. And they're right. Again, that's what the legislature intended, but doing it creatively or walking that line, you could try Jason's way.
I mean, I understand to a certain degree you're supposed to interpret what is intended by what's written, but
right. So again, my way is practical. It is kind of walking that line. There's not an attorney general opinion. There's a difference between an attorney general letter and an opinion. A letter has no binding effect. It's just information. An opinion means it's binding. So there's a letter from the attorney general's office that looked at the creative way. I call it Jason's way, but other people do it too. It's not just me. And they looked at it and they said, yeah, that's not what the law says, but we all know what they intended. They intended to do it like the corporate article, which is send out a second notice and have a meeting after July 1st on some other day, whatever. So, again, the interpretation that I've given, that I give the caveat subject to challenge, what Craig or what Michael says is absolutely correct. The letter from the Attorney General is absolutely correct. But the practical is if nobody's harmed, does it matter? Again, boards can do it either way. Managers can do it either way. A lot of managers I work with try it Jason's way unless somebody says boo about it, and then you go back to the other way.
Jason's way is preferable.
Yeah, I like Jason's.
Can you, if you decide to send out the notice on the HOA, post the notice in the paper? And you post in the paper, on the notice in the paper that if nobody shows up at 7, or we do this again at 7:30?
No, the reason because the corporate article is worded different. The corporate article says basically after. The way the language is in the corporate article, you can't do that interpretation because it basically requires you to have meeting 1, have it fail, and then send a second notice because the wording is different. So that's the answer on that issue. And yes, I have debated it with other lawyers, and we all agree it's.
But until there's a court case that's really serious.
Really, what should happen is the legislature should fix the statute if it's an issue. They've gone back and done corrective amendments before and things like that, but nobody's touched that one because, again, I don't think too many people care enough about it to raise it. Again, I've talked about this already. Conducting a professional meeting, start on time, follow a form of parliamentary procedure. So you're aware. You get kind of the know-it-alls in the room that jump up and down and say, Robert's Rules of Order this, Robert's Rules of Order that. So if you don't know, Robert's Rules of Order is a corporate way of board meetings to be conducted in accordance with Robert's Rules. So basically, if you've never seen it, it's a book of about 700 pages of like this thick, like a paperback size. And it's not a book to read. It's really a reference tool. It's like a dictionary. You look up how to do things, or an encyclopedia on how things get done in a corporate operation of a board. You can get certified in parliamentary procedure and then be Mr. Know-It-All in the room. Not worth it. You basically just have to be able to direct your boards that how business of a meeting should get done. Call the meeting to order. Keep minutes. Keep a record of the motions, what passes, what fails. So the way a board meeting gets run is like this. Call the meeting to order. Let's review the minutes of the prior meeting. Anybody have any additions or corrections to the minutes of last year's meeting or last month's meeting? No? All those in favor? Aye. Okay, minutes approved. Moving on. Looks like on the agenda we have to review the management contract that we're going to enter with ACM. We vetted all the companies. They all are stupid. We like ACM. Let's hire them. I make a motion to enter the contract with the ACM as a new management company. Is there a second? Somebody seconds. Okay, any discussion about that contract? Yeah, they're great. Let's hire them. Wonderful. Anybody else? No. Okay. I'll call the question. All those in favor of entering this contract say aye. Unanimous. Aye. Any opposed? No. Motion carries. So what the minutes are supposed to show is meeting called to order, minutes of the prior meeting approved, a motion was made and seconded by so-and-so and so-and-so to enter the management contract, and then a unanimous decision to enter in that contract. That is what the minutes reflect. You don't need the discussion about, yes, ACM is great, all the other guys are stupid. Not required. What's required is you keep minutes of the transactions and what happens at the meeting. Can you keep a verbatim transcript of what happens at a meeting? Sure. But why? Creates problems. Usually creates problems when board members want to fight with each other or when owners want to claim that something they said didn't get included in the minutes. It's not at a board meeting, it's not a unit owner meeting. This is something, again, to be conscious of. Board meetings are not meetings for the members to espouse on their opinions on the world. Board meetings are for boards to get business of the association done, transact business. What the law requires, and I'll get to this in just a minute, is, and this is in your package as well, at every meeting of the board of directors, it has to be open notice. We talked about that. The other requirements of the statute, both for condos and HOAs, is that you have to give owners or members, if you're an HOA, the ability to comment at the meeting on any agenda item. Now, you can limit it to 2 or 3 minutes or whatever the policy the board adopts, but you have to give them the ability to at least comment on any agenda item. One meeting a year, you have to give them the ability to comment on anything that they want relating to association business, whether it's on the agenda or not. So some boards are more liberal and basically say, look, if an owner takes the time to show up to a meeting, I want to listen to what they have to say. I might limit them because they may be nuts and go on for an hour, but we'll listen to what they have to say, whether it's on the agenda or not. But if the board has a published agenda, meaning a written agenda that's presented at the beginning of the meeting that's there, the board can limit comments to the agenda items. Now, practically speaking, if you're going to do that, make sure you tell people, and usually just print it right at the bottom of the agenda. Owner comments limited to 3 minutes. Members can comment on any agenda item. You know, your opportunity to speak on non-agenda items is at your annual meeting once a year. Now, most boards are more liberal. If people show up and they want to talk about something that's not on the agenda, they'll let them do it. And that's a way of also engaging the community. I have a board right now that their meetings on average have been running 6 hours. And they came to me and said, Jason, what the heck can we do to stop this madness? And I said, stick to the letter of the law. And so I said, publish a written agenda before the meeting, have it there, limit comments to 3 minutes or 2 minutes, whatever you desire. Tell owners they can only comment about agenda items, and remind them that their opportunity to speak on non-agenda items are at the annual meeting and it's the business meeting of the association's board. It's certainly going to ruffle some feathers because people have been doing this for 25 years. But one of the things that I tell all my communities is, look, if you're going to come in and change something that's been in place forever, just communicate it. Be upfront and forward and honest about it. Say, look, guys, our meetings are running 6 hours. We're paying manager 2 hours of overtime every meeting to stay at these meetings that run on forever. So we've done this as a board. If you want to come and talk to us about other things, one board member said, look, I'll volunteer. I'll have office hours every other week. You come and you talk to me about whatever you want to talk about. But we're not going to spend board time at a meeting. That board member's retired. You got nothing better to do. To sit there and talk about, why Mrs. Jones's cat is wandering outside and we've got to do something about it. It's not part of what they need to be doing. So the law says you can limit it to agenda items only, but you have to have a written agenda to do that, right? That's why it goes back to good business practice. Have an agenda set and published for the meeting. Robert's Rules of Order also, when people jump up and say, you're not following parliamentary procedure, you can shut them down really easily because a board of less than 12 under Robert's Rules of Order can operate as an informal board. What does that mean? They technically don't have to do motions and seconds and operate with strict parliamentary procedure. Most people don't know that. But under Robert's Rules itself, it says a board of less than 12 is considered an informal board, and they don't have to follow the strict rules of procedure of parliamentary procedure. So that's something to be aware of. But in terms of that parliamentary procedure, motion, second, actions, make sure your boards are at least at a minimum doing that. There should be a motion to convene, motion to open the meeting, motion to close the meeting, and everything else in between. Again, that agenda sample I gave you, new business, old business, new business, follow that format as a basic premise, works pretty good. And as a manager, my, again, practical advice coming from Jason is, as the manager, you're looked at as to kind of keep track of the board's stuff. So I've seen different forms and different formats used, but at the end of a meeting, you should have a list of what happened and what was accomplished during the meeting, but also the action items that need to come following the meeting. Oftentimes they're for you as the manager to follow up on things. So you should have your list of to-dos following the meeting. And again, I don't know, Mel, if you guys have a set form that you mandate your managers use for going to meetings. I know some companies have tried to do that, or they just rely on the manager. But you should have coming out of it kind of a task list. From the Palisades meeting last night. One is to call Mrs. Jones at 123 Main Street to get her updated address. She was at the meeting. She told us she wanted to do that. 2, the contract with ACM was authorized. Make sure the signed contract gets over to them and we get that going. 3, we're supposed to transfer $10,000 out of reserves that was approved by the board to move over to pay off the concrete work that was done last month. Action items following the meeting. There should be a written record of it, both to protect you as the manager, and so there's a record of it in case the board next month wants to try to say that you didn't do something you're supposed to do. Have the list. You might even want to go to kind of what I do as a lawyer when I go to meetings. And at the end of the meeting, I do a quick recap before I walk out with the board. Okay, just to remind you, Mr. President, you said you were going to forward me X, Y, and Z so I could look at it for you tomorrow. As your manager, I'm going to get the contract over to ACM, get that moving. I'm going to transfer $10,000 out of reserve, blah, blah, blah. Did I miss anything? You don't necessarily always have to do that, but sometimes it's a good idea. But at the very least, have your list. And that list will also serve at the next meeting when you go to do the agenda. What's still under old business that was unresolved from the prior meeting that needs to still be on it for the next meeting? And what's come up with new business? I said I transferred the money for the $10,000, but since then I got a change order from the contractor that says they need another $5,000. So that may be under new business. $5,000 request from the concrete contractor for additional funds. So again, have that list. Keep a written record as the manager to protect yourself. In terms of the professional meeting, this goes to you as well as your board members. Sometimes you might want to remind them. Start on time. Again, basic form of parliamentary procedure. Keep minutes. So when there is that open forum, I typically recommend, and everybody does it different, if you want to be inclusive of the community members that show up, have the open forum at the beginning. Some people make the mistake and they basically have open forum, then call the meeting to order. That's incorrect. The meeting should be called to order, approve the minutes, then do open forum. Why? Because the state law says you have to have an open forum during the meeting. If you have it before the meeting starts, you didn't do it right. So it should be part of the meeting. Again, you don't have to keep a note of everything that was said by the residents during the meeting. You just have to give them the opportunity to speak. The other practical thing is, when people show up and comment, sometimes they'll grill you, they'll grill the board. Your response or the board's response can simply be, "Thank you, Mrs. Jones, for your comments. Next." You don't have to respond to people that show up at the meeting, complain, yell, scream, whatever. Sometimes it's just information they want out there. Sometimes your response is, "Thank you, Mrs. Jones, we'll follow up on that and get back to you," or "The board's heard you, they'll look into it." That may be a simple response. During the open forum, positive verbal and nonverbal communication. What does that mean? Don't roll your eyes at Mrs. Jones, who's there every month, saying the same thing 10,000 times. Okay? So try to stay professional. Don't look away. Don't be distracted. This is really more for the board that's supposed to be listening to these people, but as a manager, kind of set the example as well. Formal actions. What can happen at a meeting? Policy resolutions, administrative resolutions, general resolutions, special resolutions. These are things that the boards can do at meetings. Typically, they're just doing business, transacting business, approving, disapproving, making decisions. But sometimes there's resolutions and things that they're passing. As I said before, whether it's a rule, a regulation, a guideline, they're all on the same kind of level in the hierarchy. But be careful, because under the condominium documents, for example, on the condominium statute, if a board's going to adopt a new rule of procedure, for example, a collection policy, they have to send out a draft proposed version of that policy at least 15 days to the members before they're actually going to vote to adopt it. So let's say we have a meeting tonight and the board had me draft, as a lawyer, a collection policy. I send the draft to the board. The board looks at it and says, "Yeah, we like this. Let's tweak this, let's tweak that. We want to consider adopting this." They can't vote tonight to adopt that policy because they haven't sent it out to the community for consideration. So at minimum, 15, I usually recommend 30 days. So tonight's meeting, they'll say, "We vote to have Charlene mail this out to the community as a proposed collection policy that we're going to consider adopting at next month's meeting." So she slaps a cover letter on it, attaches a draft collection policy the board is going to consider adopting at the meeting that's going to be on a month from today. If you have any, if you wish to comment, submit your written comments to me as your manager. You can send them to the board or come to the meeting and provide comments to the board at the meeting. Condo Act says you have to send out the draft proposed rule, give them the ability or the opportunity to comment, either in writing in advance or at the meeting itself. At the meeting next month, the board will say, we've got this policy for consideration. It was sent out. Charlene, yeah, I sent it out on such and such date. Met the 15-day requirement. Board says, anybody here to comment further other than what we already received in writing? Nope. Board votes and adopts it. Even if everything they got in the mail back from the community said, we hate you, don't adopt this policy, it's onerous, don't do it, blah, blah, blah. Thank you for your comments. Approved. The law just says you have to give them the opportunity to comment. Board presumably is going to take those comments into consideration. Sometimes it's things that make sense. Sometimes it's not. Now, here's the question I often get is, well, what if the board, between the time they mail out the draft and the time they get to a meeting, decide that they want to tweak it or change it, either based upon comments they got, or the board just decided, you know what, we want to impose the late fee on the 16th day, not the 15th day, as Jason had in the draft policy. It's okay, because the law says send out the draft policy. Doesn't say you can't change it before you adopt it. Now, once you adopt it, send out the final version to the community so they can update their, I'm sure, 3-ring binder that they keep of the association governing documents, like I do. But at the very least, you meet the obligation. Mel, you had a question.
Well, I just wanted, it was our policy that our collection department cannot take any action against someone who has not paid their fee unless there is a collection policy that has been adopted by the board and is published on our website. If they don't do that, then any action taken against an individual has to be directed, specifically directed against that individual by the board of directors. So we cannot send out notices of delinquency. We cannot send cases to attorneys for collection unless there is a public policy. And if the homeowners have an opportunity to review it, that's our policy.
It's a good policy.
It's a good policy.
It's a good policy. As a matter of fact, it's a policy.
Good policy, man.
As a matter of fact, the courts of late have been, by the way, courts hate community associations collections. They do. They hate us. They hate the lawyers. They hate the managers. They hate the communities because they think you guys are big, bad, ugly people beating up on these poor little homeowners. And by the way, they didn't pay their fees, but that doesn't matter. So what the judges do is they criticize everything that associations do in collecting. And so one of the new things, and Mel, it's actually good that you're doing that, is because a lot of documents say the board of directors may impose a late fee for any assessments that are delinquent. So some creative judges are now saying, well, it says the board may. That's discretionary. Where's the proof that they said they were going to start doing it? So without a collection policy in writing to show and then flash in their face, they're not accepting, well, the board approved at a board meeting. I don't see a written record of it. They want to see them. They want to see the policy. So they're actually requiring us to jump through that hoop. So it's good that you're requiring that.
Yeah. We actually asked them to vote. We want to see the vote from the board if they don't have a policy.
Yeah. So that's good. The other thing is at these meetings, in terms of complying with the law, there's the opportunity for executive session meetings. I'm going to go right to the statute in a moment to show you what's opened, what's closed, and all that. But let me jump to it here. Yeah, we're going to get to it in a couple of slides. So I'll come back to the closed meetings in a minute. But as a manager, we'll talk about it. You want to just basically remind the board of what's being done in open, what's being done in closed. And once I go through the closed session, you'll be able to educate them on that. But you want to comply with the laws, which basically means make sure that the meeting's open. If you're having the open part of the meeting and someone shows up to the door that lives in the community, remind the board that they can't throw them out if they try to. They have a right to be there. Make sure that they're advertising the meetings, that they post notice of the meeting. If they didn't follow those procedural requirements, they may be subject to challenge, which means the action that they're taking at the board meeting may be thrown out as voidable action because they didn't do it right. So, open meetings requires proper notice to all members. You're required to do it for regular board meetings, special board meetings. committee meetings, and what's proper notice? Time, date, and place. Reasonable notice. At least give them 3 days notice, guys. Don't post it the day of the meeting. I've got a community that was putting up in the elevator the day of the meeting, saying that was good notice. Walking the line a little bit. So let's talk about closed meetings. So I've got in your packages both statutes, but in terms of what's up on the PowerPoint, it's just going to be the Condo Act, because that's the one that sets it out a little bit clearer. So, Board of Directors closed meetings. So, a meeting of the Board of Directors may be held in closed session only for the following purposes. Note how it doesn't say unless otherwise provided by the documents. What that means is this is the law. This controls Trump's documents no matter what it says. So when is a closed meeting proper? Discussion of matters pertaining to employees and personnel. Okay? So, again, that's pretty self-explanatory, except you get these boards that say, look, for 30 years, when we decide who's going to be the officer of the board, we always do that in closed session. We take 10 minutes after the annual meeting, we go into a room, nobody else is there, and then we argue about who should be president or not. We don't want that to be open. Well, technically it probably should, but if you want an argument to justify it, officers of a corporation, although they're not paid, are technically personnel. They're officers of the corporation. So arguably, that gives a justification to say, well, you can walk the line and do it under this category. Again, technically, it's my belief it should be in open, but the best argument you have to do it in closed is to say, well, it's technically officers are like personnel of the corporation. You can do it in closed meetings. In my experience, probably 85% of the boards I work with always do these little officer meetings in closed session just because they don't want to disparage people in public. And, well, you know, Jim can't be the president. You know, he never shows up on time. He's not real good at doing this stuff. He's a good board member, but I don't want him being the president. That's the kind of stuff that they want to keep, you know, kind of just in the group of the five there. So that you can get away with that. Again, if it's an association that has employees deciding on, you know, what you're doing with the employee, hiring, firing, that kind of stuff, makes sense to do it in closed session, not out in public. 2, what other ways you can do closed meeting? Protection of the privacy or reputation of individuals and matters not related to the council of Union's business. Okay, well, if the board's discussing it, pretty much everything is the council of Union's business, right? Otherwise, why would they be talking about it? Some rare exceptions that may fall under that is if you're talking about the fact that Mr. Jones is having an affair with Mrs. Snyder down the street and how that affects the architectural committee because these two people can't get along, blah, blah, blah. Maybe that falls under 2, I don't know. But again, I don't see where 2 really comes into play. 3, consultation with legal counsel on legal matters. That's me. So if you're meeting with the lawyer, talking with the lawyer, closed session. Makes sense. It's also subject to attorney-client privilege, which means it doesn't go out in public. Now, the number 4 was a change a number of years ago, which basically broadened it for who could you talk to about stuff that you wanted to keep confidential. So, consultation with staff, personnel, consultants, attorneys, board members, or other persons in connection with pending or potential litigation or other legal matters. Kind of a big, broad catch-all in some respects. So, let's say you want to talk about collections at a board meeting. Well, collections is going to come up under a separate category. But let's say you're going to talk about covenant enforcement. And you're talking about how Mel's house is bright purple. It's a violation of the covenants. We got to do something about it. Well, Jason's not there as the lawyer to talk to him about it, so it's not under the first one up above about consultation with lawyers about legal action. But you want to talk with the manager, Charlene, about what are our options for enforcement with Mel. May eventually be legal action if he doesn't comply. But Jason's not here. Can we talk about this in private? Sure you can, because you're consulting with your manager, other persons in connection with pending or potential litigation legal matters, enforcement of a covenant violation. If you're talking about entering into a contract, contract's a legal matter. Do that in closed session is fine. Now, once you vote to approve the contract, it should be an open session, so there's a record of the action taken. But in terms of the discussion about which guy to go with, which one not to go with, those kinds of things, consultation, discussion about that legal issue of a contract can be done in closed session. Number 5, investigation and proceedings concerning possible or actual criminal misconduct. Doesn't come up too often, but again, it's there, criminal issues. Or 6, complying with a specific constitutional, statutory, or judicially imposed requirement protecting particular proceedings or matters from public disclosure. What the heck does that mean? So that means, is there some other law that says this should be private? Sure there is. Fair Debt Collection Practices Act. Can't talk about somebody's personal debt in public. Federal law prohibits you from discussing somebody's health issue. So for example, let's say somebody made a Fair Housing Act request for an accommodation because of their multiple sclerosis disability. Well, that should be done in executive session because HIPAA laws say you can't talk about somebody's medical condition in public. Now, you came in contact with that information because of your role as the board. Shouldn't be done in public. Should do it in closed session. There's other laws that come into play here, too. There's child protection issues that come up where there's custody fights between husband and wife, and they're disclosing information about some issue with their kid. That may fall under some protected laws as well with respect to disclosure of certain psychological issues and those types of things. There's other types of situations. Typically, those things will come with a cover letter that says this is privileged confidential. Don't discuss it publicly. Kind of tips you off as a manager. We shouldn't be talking about this in public. The lawyers put attorney-client privilege on the top, which means do it in closed session. Discussion of individual owner assessments accounts. This is the one that basically specifically says don't talk about collections publicly. Now, here's what people get wrong. But I know you as managers or potential managers or assistants will never get it wrong because you're going to get it ingrained in your brain right now. Okay? And I guarantee you there's managers that have been doing this job 30 years that are getting this wrong. So you're going to have a one-up on them. All right? If a meeting is held in closed session under one of those 7 categories, okay, the way you're supposed to do it is you can't take an action in closed session unless it's covered by one of the 7. So first of all, you can't have a closed session meeting unless it meets one of the 7 categories. People will get that one right. But here's where they get it wrong. Did I go the wrong one? I did. 2. Hold on, it's messing up here. It disappeared on me. So 2 dropped off, but I'm sure it's in your package, so let me go there. It's so important it's not on there. Let's see. It's under tab. So if you go, you don't have the tabs. Okay, so.
It's here. It's in here. It's in there.
Is it in there? Okay, so B2. So you can't have a closed session that meets one of the 7 categories. B2 says, if you have a closed session meeting, a statement of the time, place, and purpose of any closed session meeting, the record of the vote of each board member by which any meeting was closed, and the authority under which this section for closing the meeting shall be included in the minutes of the next meeting of the board of directors. Okay, let's put that in English, okay? Here's what that means is, you have a closed meeting today. Your open meeting, let's say, is tomorrow. One of my crazy boards has their executive meeting on Monday night and has their open meeting on Tuesday night because they're crazy and they have nothing better to do but spend 2 nights doing this stuff. So on night number 2, their open meeting, what they're supposed to put in the minutes of that meeting, they're supposed to stand up and put in the meeting minutes and say, FYI, on today's the 30th, June 29th at 7 o'clock p.m., the board held a closed meeting of the board of directors for the purposes of talking about pending legal issues with its legal counsel and enforcement matters. The board voted unanimously to hold that closed session meeting last night, and the board at that meeting authorized the attorney to proceed with legal action against one of our owners for a covenant enforcement matter. That's supposed to be in the minutes of the next open meeting, so that there's a record that a closed session meeting was held, why it was held, when it was held, did the board agree to hold it in closed session? Because keep in mind, holding a closed session, this is kind of, some people miss this, is an option. It doesn't say the board of directors shall have a closed session meeting for these following 7 purposes. It says the board of directors may hold a closed session meeting for these 7 purposes. Means it's discretionary. Of course, it darn well makes sense to do it in closed session for those 7 reasons. But the board still has to authorize them and make a decision and say, yeah, we're going to talk about our legal action against Mel for the bright purple shutters in executive session. Because why would we do an open session to talk about what action we're going to take against him? To give him a heads up of it, it's coming. Or to talk about what we're going to do in terms of sanctions we're going to impose. So first the board has to vote to take action to go into closed session. Usually it's kind of a given. Everybody says, yeah, let's do closed session. There's one board that does it every month at 7 o'clock on Monday nights, on the 4th Monday of every month. They've all kind of agreed in advance to do it. But you have to have a record of it. So at the next open meeting, you got to put it in the minutes. How many times do boards get it wrong, or managers not know to do it? More times than not. And unless you've got that one owner, like I said, that calls the board on every technicality, probably nobody's calling them on it. But this is the way you're supposed to do it. So at the open meeting, you're supposed to put all that in the minutes of when the closed meeting was held and what was done.
That vote is taken in the closed meeting, it should have been put in the minutes. It says you have to identify the vote of each board member, which any meeting is closed.
Right, so the first issue is the vote of the board that's authorized to hold a closed meeting. So in my example, I said it was unanimous. The board members all agreed, let's do this in closed session. And that's typical. Usually the board all automatically kind of agrees, we're going to talk about these legal issues in closed session, and there's no deviation. But like in that one board I've got that I've been handling litigation for, it's 4-1 every time. 4 of the board members say, yeah, we've got to talk about legal issues in closed session. The one guy says, everything should be transparent. We should be doing this in open, everything in open.
So the vote that you're recording in the minutes is the vote to have the meeting, not the vote that was taken at the closed meeting.
Correct. Now, to have a record of what happened as a transaction, I say go one step further, which is kind of what's intended, is to say, I had a closed session meeting, here's the purpose of the closed session meeting, and it can be a broad purpose. You don't want to obviously say, we were talking about Mel's purple shutters and our enforcement action. You can just say, the board reviewed existing covenant violations and potential legal action against those violators. That's enough. Or the board authorized proceeding with foreclosure on delinquent owner at certain properties. That's fine. The other thing too is, I don't get into it a lot now with this session, but I do have it in the packet. There's a books and records disclosure provision of the statute that basically says any member or owner of an association has a right to request and review books and records of the association, which includes contracts, transactions, anything that's a record of the association. They have a right to review and copy at their expense and see it. Clearly, the books and records of what happened at a closed meeting that was authorized to be an executive session, you don't have to give them. And the statute for books and records says they get everything except the stuff that was authorized to be in closed session. So some boards keep detailed minutes of closed session meetings. They can still be withheld under the books and records disclosure requirement. But I do caution you, this is me putting on my legal hat. Despite the fact that the statute says you don't have to give minutes of a closed meeting, if they get into litigation, discovery, which is the legal process under which people can request information of the other party in a lawsuit, doesn't preclude them from getting minutes that were kept in closed session, unless it was with the lawyer. It's the only exception. So that's why I tell boards, don't keep minutes of closed session meetings, like detailed. You can keep record of the action, but not the detailed minutes, because if it gets into discovery, you could be required to disclose it unless the attorney is part of it.
So if
Go ahead.
the attorney was a part of it, you don't have to disclose that if there's litigation? Is that what you're saying?
Right, because it's subject to what's called attorney-client privilege. So there's other provisions of law that protect it. So again, that second part of putting a record of it in the next open meeting is required. Most people get it wrong, but you won't, because now you know. Yes?
Is it, this is kind of a nitpicky question. If one of the board members is an attorney but is not necessarily representing them, does that cause
No,
the
so
whole thing to be underneath?
no, so the privilege is only legal advice from
Specifically intended for a board and their purposes? Okay.
yeah, excuse me. Yeah. A lot of boards have lawyers on them and they can't use that as their way to say, hey, everything's closed session. Also, there's actually a case in DC where a board went to the expense, not one of my clients, of having the attorney at every single meeting of the board, and then tried to argue that, well, every single meeting was therefore closed and not subject to scrutiny. And the court said, no, it's legal advice on pending legal matters, and just having the lawyer in the room doesn't make it a closed meeting. There it is. So number 7 popped in. So there it is. There's number 6. So I'm going to switch gears now to covenant enforcement. And let me see what I'm doing on time. 2 minutes left. Well, I might go a little bit longer now. Okay. Covenant enforcement. We'll take out time for lunch, so that doesn't count. So covenant enforcement. So covenants are the restrictions in the association's governing documents that say you can't create too much noise, you can't create a nuisance or annoyance to your neighbor, you can't have things on your property that violate the law. And so, again, the board of directors has an obligation to ensure that the community is in compliance with the governing documents. How do you do that? Well, you keep an eye out for things that violate them. Typically, they come from complaints from the neighbors, from the manager notices things, or, you know, some communities are organized enough they have committees that walk the community to look for things. Or nowadays, there's a third-party company you can hire to do it for you, from what I'm understanding. So, ensure compliance with the governing documents. What are the biggest issues that come up? Maintenance issues and use restrictions. What's a maintenance issue? The shutters are falling off the house. The lawn's 3 feet high, hasn't been mowed. The paint's peeling off the doors. Maintenance issues. Use restriction violations. Can't operate a business out of your house. You can't, change your engine of your car in the parking lot. You can't, do other types of things that your documents say you can't do. Your documents say no pets, you can't have a pet. Some documents say you can have pets, but you can't have lizards, you can't have reptiles. You can't have that. Some documents say you can't have chickens. I had to enforce that once. Or actually more than once. But, and just so you know, it's hard to prove a chicken is an accommodation animal under the Fair Housing Act. Somebody tried that one too. So when the community finds violations, what do? You send a notice of violation. Typically it's the manager that has a form that you're sending out. HOA Act, again, very liberal, not very specific about what has to be in the violation notice. Some documents of more modern HOAs say specifically an enforcement policy that says, when you send a notice of violation, here's what you have to include, X, Y, and Z. Again, Condo Act, very specific. So, the Condo Act, and I've included the copy of that statute in there as well. In your package, there's a you've got the 11-113 rule adoption, and then get to it in a minute. Just want to make sure it's there. Yeah, 11-111, rules and regulations. So if the board adopts rules, you got to follow 11-111, which says how the rules are adopted and how, that's what I was talking about, 30 days in advance. 11-113 is also in your package, which is, it's called dispute mechanism provision. This is basically the enforcement process. So for condos, it's very specific. A lot of associations have adopted an enforcement policy that kind of mirrors this, or is this as part of their documents. So it's kind of onerous, but it basically is a due process type of thing. Somebody violates the documents under the Condo Act, you have to send them what's called a cease and desist letter. You give them a 10-day notice. So it says, it's been noted that you're violating the association's governing documents because you're creating too much noise after the hours of 9 p.m. at night. Your neighbors are complaining. You have 10 days from the date of this notice to stop it. And the way you stop it is stop creating noise after 9 o'clock that's disturbing your neighbors. If you don't stop it and it occurs again after the 10 days or within a year of today, 365 days, we're going to send you a second notice, and it's going to be a notice of hearing. And if you don't comply with that, you could be subject to sanctions, which is fines and other enforcement action that may be authorized by the governing documents, which is basically usually taking away their right to vote. Some documents is taking their right to use the pool, the spa, the facilities, whatever the sanctions that are possible is, you got to tell them what may be coming. The 10-day cease and desist, again, by now your office has forms. Management companies that are smaller than yours and not as experienced, sometimes I find that their forms are wrong because it doesn't have the right language, but it's basically cease and desist, what they're doing wrong. You have to say you have 10 days to stop it. If you continue past the 10 days or within 1 year, here's what could happen. You got to tell them that too. That's what you've got to put in that notice. If they violate again, the second notice, the notice of hearing, has to specify, again, here's why you're violating. We're scheduling a hearing to talk about your violation. And whether you show up or not for the hearing, we're going to have a hearing to determine whether the board believes A, you violated the documents, and B, if you violated, what sanction, if any, they're going to impose. And then list the possible sanctions. Fining, taking them to court, getting an injunction, whatever it may be. And if you're in Montgomery County, Maryland, you have to include a notice from the Commission on Common Ownership Communities, which is a blurb from 10B of the code that says, and if the board holds a hearing and determines that they find you in violation, you have a right of appeal to the CCOC. That's the mechanism. The benefit of this whole due process is condos are given the ability, either whether it's in their documents or not, that if you go to enforce against somebody and they don't comply and you have to take them to court, the Condo Act says you get attorney's fees if you are the prevailing party in court. HOA, you only get attorney's fees if you have a right by contract or statute. Statute's silent, so unless your governing documents gives you a right to get attorney's fees for enforcement in an HOA, you cannot get them in Maryland. It's called the American rule. Enforcement is a very tricky thing. Condos always have the right to fine because it's in the statute. HOAs, you only have a right to fine, as I said before, if it's in the governing documents and specifically in the declaration aspects of the governing documents. Otherwise, it's not part of the, quote, contract, and therefore courts have said it's not in the declaration, it's not something that can be upheld. So if your fining authority is not in the declaration, courts won't typically uphold it. In terms of the covenant enforcement, again, hearing on any alleged violations of the governing documents is a due process. Even if you're in an HOA that doesn't have an enforcement policy that has all this, I always recommend you follow due process anyway. It's safer, and if you end up having to go to court, which I often do for associations, judges are much better in awarding you a victory if you can say, we gave them every chance in the world to fix this before we brought them to court. They want to see that you gave them opportunities. Notice hearing, right to appeal to the board. If it's a committee that's enforcing, there's typically in the documents a right of appeal to the board of directors. Now, once you go to enforcement, what are the ways you can enforce? Self-help. Self-help is a mechanism where basically the documents say that if a person fails to maintain their property and after reasonable notice the owner hasn't, the board has the right to come on the property, correct the violation, and charge them back the expense. That's self-help. You can do that typically really easily with lawn maintenance, things like that. Boards sometimes are reluctant to do it for shutters falling off. They don't want to go to their property and do that kind of work. But they have the right to do it, and under the documents and the law, it's not considered trespass because you have a right of easement and a legal right to go on their property. Letters and communication, hearing and right to be heard, we talked about that. If these things don't get you what you need, or if you try self-help and they stand at the door and say, you can't come in, get out, I'm not authorizing you to come in here, even though you call the police and stand there and wave the association's governing documents and say, I have a right of easement for self-help, the police say, don't care, not my job to interpret the piece of paper, go get a court order. It also is another way of basically saying that in Maryland you can't breach the peace to enforce an easement right, which basically says the person tries to stop you physically at the door or tells you can't come in, you got to go to court and get a court order. So a sneaky way you do it is you schedule it when you know they're not going to be home, you get it done. Practical. Circuit court action. The only way to get injunctive relief, which is an order from the court to do something or not to do something, to authorize the association to go on the property to do this work, get a court order, get it done. Order somebody not to do something. Stop creating the noise that's creating a nuisance to your neighbors. That's an injunction. Requires you to go to the circuit court, which is basically the court of jurisdiction that hears those types of actions in Maryland. In Montgomery County, you have the option to go to an administrative agency that's set up. It's like a court, but it's an administrative agency, and it's a 3-judge panel, and basically it's comprised of typically a lawyer, a manager, and a volunteer that's served on a board who lives in a community like an HOA or a condo. They're appointed yearly by the county executive. There's 15 people that serve on the commission. When you have a hearing, it's a 3-judge panel comprised of the people I told you. And if you go there, they try to force down your throat the idea of mediation, which oftentimes will help you get it resolved because they bring you in a room with the other party and they try to help mediate the resolution. And if not, you go to a hearing. And then the decision's enforceable like a court order. But the benefit actually of the CCOC is the enforcement can be done by the county attorney. So you let the county do your dirty work for you and go after them if they don't comply. Works in theory, not so much in practice, but that's a whole different story. If you go before the CCOC, you have a right of appeal to the circuit court anyway, so you might end up there. The CCOC used to be a good thing because you could get everything you wanted from court, but quicker, cheaper, faster. Now it takes longer, you can't get everything you want, and the process takes longer, so it's not as good as it used to be. The reason I say you can't get everything you want because the county in its infinite wisdom took away the right to get attorney's fees. Even if you have a right of the documents or a right in the statute to get attorney's fees, the CCOC doesn't have jurisdiction to give them to you anymore, except in a rare circumstance if the claim filed by the party was frivolous or unjustified. So it's a waste of money because you end up having to go to court to enforce your attorney fee right anyway. Yes.
This sounds similar to other free services that are provided from some of the counties for like, mediation and things like that. But the difference sounds like that this is enforceable by law. Am I correct?
Right. So a lot of the counties in the city of Baltimore, they have, community, community housing affairs will have a mediation service. Oftentimes it's landlord-tenant issues that they deal with, but they'll deal with CA issues as well. It's voluntary and it's not binding. It's just they try to get the parties together to resolve it. The CCOC has an actual hearing process that it's more like a binding arbitration aspect of it, that if you can't resolve it voluntarily in mediation, you go to an arbitration panel that decides it for you. And then it's binding. Let me jump to Joanne's favorite, assessments and collections. So let me talk about assessments. There's a lot to it. Bottom line is, when you live in a community association, as I said, you have an obligation to pay assessments that are typically established by the board. Some rare documents say that the community actually has to approve a budget. Most communities, the board does it. It basically empowers the board to collect assessments, and there's a process. Again, we talked about passing a collection resolution to how to do it. How you make sure that things are done in a community so that they're done right. Set out the procedures in a policy, like we talked about. Clearly communicate to the owners when assessments are due, what happens if if you don't pay on time, you get late fees, when they're imposed, interest, scare them with the fact that if they don't pay, they're going to go to the big bad lawyer after Joanne beats up on them for a while. And then we collect. Thing that the boards need to do, and make sure you remind them as manager, is be consistent. Don't give special favors to board members, to friends of board members. That's why you have a policy. Enforce the policy. The policies should be reviewed. It says annually, but again, you don't have to look at it every year. But the one thing you might want to consider every year is make sure that what you're doing as the management company in your process is consistent with what the policy says. So sometimes you guys may change your internal procedures, but the policy doesn't get updated in terms of when things are getting turned over. This goes with everything, but especially collections. Consistently communicate to the owners about the obligation to pay and what the assessments are for. That's why I say when you have your annual meeting or when you do your budget meeting, explain what the money is going to support in the community. Because you often get the, well, what do I get for my money? Okay, well, explain it to them. Tell them what they're getting. Trash removal, snow removal. Somebody's got to cut the lawn. Somebody's got to pick up the trash. Those types of things. Again, communication to start with your budget in the annual meeting. Continue to communicate what it's for with welcome letters, resale packages, website newsletters, general correspondence, remind people of what's going with their money. Again, explain why prompt payment of assessments is important. Establish collection systems. Again, you have a process where you can pay online now that's beneficial. Get as many people as you can to sign up for that. It does worlds for helping collect. Again, I talked about this before, you have to maintain separate accounting for each owner that keeps a complete track of their transaction. You guys do that. There's no issue here. So jumping ahead, again, so let me talk about a little bit of the legal process. So once someone's turned over to collections, it's important to understand what happens. And I've given you in your package kind of the collection timeline called General Collection Timeline and Procedures. It's basically a document that I created that kind of gives the managers and board members kind of a primer of when it goes to the lawyer what happens in the process. Well, again, it starts with the demand letter that we send and goes all the way through enforcement. So the big things for you to understand is after the demand letter gets sent is, and Mel, are you guys doing your own liens or you're not doing your own liens? Not anymore, right?
No.
Okay. So the first part of the process after the demand letter, which is the scary lawyer letter that says, you're now in collections, pay up in 30 days or we're taking your firstborn. That's the first letter. Oh, but if you want to work out something in the payment plan, give me a call. Okay. Typically, people don't respond to the demand letter, but by federal law, I have to send an initial notice that tells them I'm a collector for the association. After 30 days, I then send a notice of intention to create lien, notice of acceleration. So here's a concept you may or may not understand. A board adopts an annual budget that says people pay typically monthly or quarterly assessments. It's a privilege to pay monthly versus being hit with a bill. Let's say it's $100 a month. The board passes a budget that says every owner should pay $1,200 a year in assessments. But because we're nice, we'll let you pay monthly, $100 a month, so long as you pay timely. But if you don't pay timely, the documents say we have a right of acceleration. Acceleration basically says that if you miss typically 2 months worth of assessments, I can demand the rest of the fiscal year now. You lose the right and the privilege to pay monthly, and now you got to pay me everything. So 2 months go by, they owe $200. Month 3, I now accelerate, they owe all $1,200. That's sort of called acceleration. It's provided for in the documents. It's provided for in the Maryland Contract Lien Act. It gives the right of doing it. But before I can accelerate, before you guys as managers can have the account accelerated, you have to give the statutory notice saying, we're going to do this unless you pay us. Now, technically, the law says I have to give them 15 days notice before acceleration. We typically give them actually 30 days from a real standpoint because the same notice of acceleration is also the notice of intention to create lien. And I'll explain that in a moment, but the notice of intention to create lien, also called an NOI, we have to give a 30-day notice. So we basically just lump it in and say you got 30 days to clean this up. At the end of the 30 days after the NOI, we have a right to file a lien. A lien is a document that we record in land record that goes against the title of the property that creates what's called a cloud on the title. It prevents the owner from voluntarily selling, refinancing, or otherwise transferring the property without paying off and satisfying the lien. The other reason we want to accelerate is because I'd rather record a lien for $1,200 plus late fees, costs, and legal fees than $200 for late fees, costs, and legal fees and have to redo it every couple of months. I can do it once per year, covers the full years of assessments plus interest. I'm required in the NOI to give them the details of what's outstanding and what's owed and what we're going to lien for. The reason why it's important for you to know what I'm doing is because when the board asks you at a meeting, The owner says they didn't know what they had to pay. You can say, well, I know they do because Jason's notice or the lawyer's notice, by law, had to tell them everything that was owed. And whether it's my law firm or whether the law firm you're working with, every law firm that does this work is always telling them in their notices. And if you want to work with us to resolve this, call us or contact us. So it's not like we're not open to getting calls from the owners. All the lawyers and managers alike are encouraging people in the communications to try to work something out. The other thing the lien does is once it's filed, it makes the association what's called a secured creditor, which means if the person files bankruptcy, which we'll talk about in a moment, a secured creditor essentially in a Chapter 13 or Chapter 11 bankruptcy gets paid dollar for dollar the value of the lien. Versus if you don't have a lien, you get virtually 10 cents on the dollar, or really these days, you get nothing. So by having the lien, the association will get paid through the bankruptcy plan that's ultimately approved by the court if you have a lien. Without the lien, you don't get it. That's why it's important to have it. It also gives the board the power and authority to foreclose on the property by virtue of that lien if they need to. Also, if the lender forecloses and there's a surplus, meaning money left over after or equity, you're next in line in the chain. So mortgage companies here, the association's lien, they get paid what they're owed. The foreclosure sale had money left over, it'll come down to you next in line to get paid something. So beyond the lien, so the lien gets you secured against the property, does those great things I told you, but it doesn't get you what I like to say is dollars in the door. The lien's a piece of paper recorded against the property. It doesn't encourage them to actually pay. So how do you get the cash? Cash is you got to sue them personally. The way you get the cash is you take them to court, sue them in district court typically, get a judgment against them personally. A judgment against them personally gives you the ability to garnish wages, garnish bank account, attach assets, cars, automobiles, motorcycles, anything you can think of that's personally owned by them, you can go after. You can even go after rental payments. So if they're renting the property, you can garnish rent. So you can file a garnishment that basically tells the tenant to pay you instead of the landlord when they're renting the property. Because basically you can intercept any money that's supposed to go to the owner for the property to satisfy a judgment. And we have attached cars, boats, other assets. Now, oftentimes cars don't have equity, so it doesn't make sense. But it certainly does enough to scare somebody to have a big old sheriff's sticker put on their window that says the car's been seized and it can't be moved, or it gets towed away by the sheriff's office because we've levied against it. People are usually pretty quick to jump up to try to get it satisfied. Keep in mind with the garnishment of a bank account, if you've got a judgment for $10,000 and we hit an account that has $10,000, we get it all. If it's got $8,000, we get it all, plus they still owe us $2,000. That's a great thing. Garnishment of wages is a little bit different. Garnishment of wages says you can't take it all. You can't basically take their whole paycheck. You can get 25% of their disposable wages. So after taxes, all that kind of stuff, you get paid out until the judgment's satisfied. You have a question?
Percent of disposable wages after their cost of their rent,
No, not after their rent. So basically it's what's
25%
of their net. So what's federally mandated that they be withheld. Taxes, health insurance, child support is the only thing that goes in front of you. Everything else comes to you. And it's 25%. So sometimes we get a windfall. We hit a doctor, a lawyer, a financial advisor that's getting big paychecks. 25% can be a big amount of money. Sometimes it's $23 every other week, like one of the accounts I was looking at yesterday. Just depends. But you have the right to enforce those judgments. The judgment in Maryland is good for 12 years and renewable for an additional 12. So that means even if they're cash poor today, sometimes I'll tell the client, let's sit on the judgment, let's leave it there. Every 6 months we'll pull a credit report and see what's happening. I've gotten calls 8 years after somebody's been foreclosed on, moved away, but the judgment's still good, and they want to satisfy because it's still hurting their credit and they want to pay it off. So in a bankruptcy, let me just go through some basics. Bankruptcy is very complicated, but there's some fine points to understand. So when somebody files bankruptcy, there's something called the automatic stay that automatically goes into effect. Automatic stay basically is the court's way of saying, step off. Do not come after this person. You can't touch them. You can't garnish them. You can't try to collect this money while the court's reviewing this bankruptcy plan that they filed. And it's called a stay because essentially it's stay away. Creditors must stay away from the owner or by the delinquent person when they're in bankruptcy. So all collection activity must cease to avoid violation of what's called the automatic stay. Collection activity includes if you've revoked their pool pass, you've got to give it back. There's a case on that. If you revoke their parking privileges, you have to give it back. There's a case on that too. You can't basically continue to penalize them because they are a delinquent owner during the bankruptcy stay. Now, the bankruptcy stay applies to the day that they filed, and the way it works is like this. So it's like a timeline. Okay, so all this time, Mr. Bankruptcy is not paying assessments for all these months. He files on this date. Let's say it's June 30th, right? Everything looking backwards is rolled into the bankruptcy pool, okay, the pot, okay? No artistic talent by any means. So all of this is part of the bankruptcy plan. So this date going backwards, we can't do anything to try and collect it. Technically, once they file, going forward, it's called post-petition. That's called pre-petition, post-petition assessments. Petition is the day of filing. Post-petition assessments, they're supposed to start remaining current on assessments going forward. Practically speaking, it takes at least 4 months for them to start even paying post-petition because during that time period, the court's reviewing the plan, approving the plan, assessing it. So they're supposed to maintain current going forward. Now, the old pool of money, the pre-petition debt, is rolled into a package as part of a bankruptcy plan, which basically means that the owner is supposed to tell the court, here's my plan to pay it off. So there's essentially, for these purposes, 3 different types of bankruptcy. Chapter 7, Chapter 13, and Chapter 11. Chapter 7 is basically where somebody files bankruptcy and throws their hands up and says, I can't pay anybody anything. I'm destitute. I got no blood left in this stone. I got nothing to pay anybody. And I got no money coming in to pay anything. So what they do is they say, take all that debt, throw it away. If they're secured creditors, like the mortgage company, they can take the house back. If there's a finance company that has a finance on my car, they get the car back. Except there's statutory laws that says a person gets to keep a little bit of money in their pocket called exemption. So just for sake of discussion, figure it's like $5,000, $7,000 per person they get to keep in their pocket or the value of that. So irrespective of bankruptcy, the court says we're not going to leave them completely destitute because conceptually then they just go to the county or the state and get money from them to live. So they leave them a little bit of money. But other than that little bit of money and basically getting to keep a couple things that they're allowed to keep to continue to work and what have you, it's all thrown in there. So Chapter 7 basically is you can figure if it's a community association, they're going to lose their house at some point through the bankruptcy. And a Chapter 7, usually between 4 and 8 months is as long as it takes to process it. So it's a quick in and out. Usually the house goes to foreclosure after that. And the association, from a financial standpoint, has to write off all of that debt. You're never going to get it. As a secured creditor, you can collect on your lien, but if the house was underwater, you're not getting anything out of it anyway when the mortgage company forecloses. Chapter 13 is reorganization. That's better for the association. Chapter 11 is also better. The difference between an 11 and a 13 is a 13 is what most individuals file for what's called reorganization. Chapter 11 is typically for businesses, but it also applies to individuals that have a bunch of investment properties as a business. So typically you're going to see a 13. And the 13 says, I can't keep up with all this. But if you give me a chance, I can take the money I'm going to have coming in tomorrow. I can continue to keep up with what's going forward. So starting at 0, pay my monthly assessments, and I'll put a little bit of money aside over the next 5 years every month to pay these people off. So it's like a court-mandated garnishment. So the trustee, who's the kind of the bankruptcy guru that controls everything once somebody files bankruptcy, let's say that they're gainfully employed, making $1,000 a month. They take $300 out of the paycheck a month. They'll give it to the trustee. The trustee starts sending a little bit of money to everybody, the creditors, according to what the court says they have to pay them. The other $700 a month they use to pay off the creditors that are coming due with current assessments, current obligations. Now, the promise is that they give the trustee that money that automatically goes to them for garnishment, and that they pay these people going forward. Now, this is a promise of good faith. If they don't keep up with the promise to pay those future assessments, the post-petition, then we can file a motion with the court to throw them out of bankruptcy and say they haven't met their plan, they're not keeping their promise, so the court should not be kind to them anymore and make us stay away. And then we can go after them. But it has to be court approved. There's a process that we lawyers do to secure our claim, to say how much they owe. It's called a proof of claim. I talked about pre-petition, post-petition debt. And in Chapter 7, again, liquidation. The goal is for them to get out from all their debt and go away, start over. I've explained kind of what the expectations are. So again, in a Chapter 13, you can tell the board you're going to get paid something, but it's going to probably take you about 5 years to get paid off. What you do internally as a management company is you split the account. So you have a pre-petition debt account. So when Joanne gets trustee payments from me, she knows to apply that to the old debt. But when the guy pays the current assessments, or the woman pays the current assessments, there's a separate account for current assessments going forward, and they apply it to the post-petition. It's the attorney's job to remind the managers and the management company to split the account. Joanne's been doing this a few years. She knows to do that automatically. And as the manager, you need to understand when the board says, well, why are there two accounts for Mrs. Jones? Well, that's the pre-petition bankruptcy account, and that's the post-petition. And you can refer back to my little notes that can explain to them what that means. I explained the motion for relief from stay is if they don't keep up with post-petition, we throw them out. So let me tell you again what's in the packages I've given you. So again, there's differences between the Condo and the HOA Act. I've given you the open meeting and the closed meeting statutes for both. Just so you're aware of it, you have a whole department here that handles your resale packages, but I wanted you to at least have the information about what that's for. So when somebody buys a property in one of your communities, they get a resale package, which is all the governing documents and disclosures about budgets and assessments. The provisions of what's supposed to be in there is in the statute that I've given you here. There's a provision on the common elements for condos that kind of explains more specifically what I gave you generally. I've also given you, again, the open and closed meeting, rules and regulation adoption process for condos, the enforcement process for condos as well, and the insurance provisions of the Condo Act also. Insurance in condos is also very complicated. I think for purposes of today, I'm not going to get into it, but certainly as you all have questions about it going forward, I'm sure Charlene will send it to me. But just the general premise is in condos, keep in mind that condominiums under that master policy, I explained the general liability. Condominiums are required to maintain insurance on the common elements and the units, excluding personal property and improvements and betterments of the owners. Improvements and betterments basically means if the condo is built with carpeting and they've added hardwood, the condo is not required to insure the hardwood, but only up to the level of the carpeting. But why that's important to understand is if there's a casualty of flood in somebody's unit, your immediate reaction might be, call your homeowner's insurance, don't bother us. But the statute and the condominium documents say that the condominium has to carry a comprehensive policy that covers all the property, under the same premise that I spoke to you before about the balcony, that if the balcony fell off, it would affect everybody else. Just as if somebody's unit gets flooded, let's assume that it's the second floor and the sprinkler pipe burst, it's going to flood their unit, the unit below. Condominium Act says, look, we got to ensure and make sure the integrity of the entire building, because there's what's called lateral and horizontal supports for everything around it, are maintained. So the condominium wants to make sure that the unit gets fixed so that it doesn't impact other units around it. So everybody pays into that master policy. Now, there's a whole area of who pays deductibles and what can be assessed back to the owner, but that's a different story for another class. So I covered a lot, probably talked fast at the end. Lost my voice here and there a little bit, but questions on some of this that I haven't answered?
That you have an answer?
Or that I have answered you want to hear again?
I do have one. Once accounts are turned over to the attorneys, sometimes we'll get phone calls about the penalties being taken off of their credit report, and we refer them back to the attorneys or to Joanne. What is the process that y'all follow to have that?
Okay, so most firms do what my firm does, which is this. We don't actually, we're a licensed collection agency, and we actually have a relationship with Equifax where we can pull credit reports in-house on delinquent owners versus outsourcing. So we have access to the information. But we don't report to credit agencies or credit bureaus.
Okay.
And as far as I know, no attorneys do that on behalf of the associations. And in fact, in some respects, they shouldn't be or they can't. But what happens is once a judgment gets entered, the credit reports pick up that public record information and put it on their credit report. The only obligation we have as attorneys, and the association has, is once the debt is paid, is we file a notice of satisfaction or a line of satisfaction with the court saying it's been paid. But we do not send, and we don't have an obligation to send anything to the credit bureaus.
Okay.
And the credit bureaus sometimes have a lag. They'll pick up the paid off judgment, but usually it's months after it's been paid. But that's not our responsibility. Practically speaking, again, practical standpoint, the owner also received a copy of the satisfaction when we file it with the court. Typically what they can do on their own is contact the credit agency with a copy of the satisfaction and say, take it off my report now, it's been paid, with proof. But that's on them, not on us.
Okay.
So we can advise people to do that?
No. Don't advise them to do anything. Don't give legal advice. You should basically
We don't do credit reporting.
No, but you guys typically get phone calls. People call and say, it's still in my credit report, I paid this off.
Yeah.
And you basically...
They gotta talk to you.
Yeah, so basically when they call me, that's what I
We
call
don't
them.
do it because we don't have really conclusive proof that person is the same person that was on the credit report. Because we don't have their social security.
Right. And even though I do, the reporting requirements are so onerous and there's so much penalties and sanctions if you're off. So like if you're off by a penny, you can be hit for violation of the Fair Credit Reporting Act. I mean, that's how crazy it is. So we don't do it.
It's just nothing but exposure for us.
Right.
I should do it on landlording.
Right.
But we had that information.
Right. Yes.
I think you had talked a little bit about board members. We have a board president, and all the different cabinets, and one board member never comes to the meetings. So I guess that's where in a closed meeting, the other boards can discuss about this one board member that never comes and how to get vote that person off. But that person still thinks they're on the board. They don't include that person in the emails.
Yeah. So now, again, remember that a board member can't be voted out of the board unless it's done by the membership, or unless the governing documents specifically say that. I was looking at a set of documents yesterday that says if a board member misses 3 consecutive regular meetings, the other board members can vote him out for not showing up. But the documents have to allow for that. Most documents don't have that language and basically say that a board member serves until their term is up, until they resign, or until they're voted out by a vote. And typically it's a vote of a majority of the members, all the members. So going back to the point earlier, sometimes boards will operate with effectively 4 board members because one guy never shows. And so practically, again, what I suggest is contact him and say, look, you're obviously not available to meetings. Maybe you should just resign. We can get somebody appointed that can kind of show up and do the job. Yes?
If you garnish someone's wages, isn't that like, isn't the state made aware of that? In other words, if that person's not working and unable to pay that, and then they get a job, 5 years later, isn't there something in place where the state says, all right, they're now working, and sort of a flag goes up and says, all right, we're going to start garnishing his wages?
No.
So they have to go back to you, as you had said earlier, to say, check to see if this guy is employed, and if so, I'll
Yeah.
instruct.
So I could file a garnishment today, and the guy's not there, but let's say he starts the job tomorrow, I'd have to refile the garnishment because it's basically as of the date that it hits. Same with bank accounts. When I file a bank garnishment, sometimes we get lucky. If we hit it on the 14th of the month when the court sends it over, and it's before payday, there might be $200. But if we hit it on the 15th of the month and they just got their direct deposit, we could get $2,000. It depends on the timing.
So, would be very aware, right, when you submit for that.
Mind me, that struck a chord with me, did it?
Yeah, and there's a whole category of different organizations where you cannot garnish practically or legally. Like the World Bank is considered an international organization, like a diplomat. You can't garnish World Bank. You can't garnish IRS tax refunds. Now, most people today are doing the direct deposit of the refunds. So if, again, around April, I do a lot of bank garnishments to try to hit the bank accounts when the refunds are coming.
So you're hitting the bank account, not the actual refund, and it's one money that.
Yeah. There's a whole art to this.
Gotta be on your game.
So that howling we hear around April is because of you.
Right. Yeah, that and then usually in June and May for pool season when people can't get their passes and they want to pay.
For a resale package for an HOA, who is the vendor?
The seller. So if it's the builder, the vendor, and that's referred to in the statute.
Resale, right? It's not a first sale or resale.
Okay. So the vendor is still technically the seller of the unit. It's not the association. In a condo, it's different. Condo, the association has specific authority, or specific obligations. In an HOA, it's still really the seller of the unit. Now, between the seller and the association, there may be obligations under the documents to provide information. But the language of the statute that refers to vendor doesn't really apply to the association. Now, they just, as you probably were, they were trying to change the statute in terms of who had to supply what in resales. It didn't pass. But they were trying to make the HOA similar to a condo, which put associations with obligations.
I think that was just confusion, really, that they when that was said.
Yeah.
I don't think that was their intention. I don't think they understood.
Well, they did. Yeah, I agree.
So then who's responsible for making sure the buyer gets those documents?
The seller has the obligation to provide it, but practically speaking, the association will get a request to management that says, I need this information for the resale package, which you guys do. You give you charge whatever you charge for the governing documents and the budget and all that information.
We put all the documents and everything up online. The homeowner can get that. But there's no charge for that. But if they want that certificate, then there is a charge.
Yeah. And they were trying to put a cap on the amount that you could charge for that, but they didn't pass either.
That's correct. Yeah. Now there is no restriction. There would not be any restriction, even on what they were trying to pass, for the information required by the lender.
They were trying to put a $150 cap on the resale packages, which is different than the certificate.
Company and the lender.
Yeah.
And that's really where all the cost is.
Yeah. And I think September 1 of this year, there's no more HUD disclosure. It changes all to the new system, which is like an electronic system. So there's no more HUD 1 statements. It's going to change. It's going to look completely different.
At all on any title transfer, any transfer real estate, you know that one?
Won't be. It's not going to be a HUD 1 anymore. Something different.
You don't have to access that online?
Yeah, I mean they have to disclose it paper form too, but it's all electronic based system. It's going to standardize how title companies do resales. Theoretically.
But they'll still do the lien searches and
right. They still have to do title. They still have to do title searches. Yeah.
Well, that should reduce the cost.
You would think. I think that's the reason they were looking to do it, but we'll see.
Fine with us.
Yeah.
They stay off the phone.
There's no questions?
Yes, one more question. How do you handle when homeowner is deceased and you are trying to collect up to, now 5,000, 10,000, I mean, it's just still building. And the house hasn't, went over, it's not in the state, it's just still family living, but you still are collecting and pursuing this deceased person.
So there's different things. One is if the person's dead, you have to, the way you protect yourself is one, to get a lien recorded against the property to put a cloud on the title, so that when the estate does get open and tries to sell it, they have to pay you off. Excuse me. The other side of it is we have properties where the owner's deceased and we can't find the relative and unit's vacant. At the end of the day, if an estate doesn't get opened for that person, a creditor has the right to petition the court to open the estate just so we can collect. So, for example, I've got a property now where father died, brother died, father died, the son died, no next of kin apparently, and we waited so many months, and so what we've done is we liened it, and now we're petitioning the court as a creditor to open up the estate. And basically what will happen is it'll be a paper transaction, but basically they'll open up the estate. We'll probably have somebody else in our office assigned as the trustee for purposes of the estate, just to basically liquidate the assets and pay us off. And then there's a public notice, I guess it gets advertised and all that. But so a creditor, technically, if there's an estate with nobody that ever opens it, can file and have an estate open.
But in that case, there's nobody in that home, is what you're saying?
It's vacant property.
It's vacant, okay.
Yeah. But I had another one where there was basically somebody just living there as a tenant, and we basically petitioned the court. We got them to pay us the rent, but we could have also had them evicted. Anything else? Okay. Most of you stayed awake. So it's a lot of information I threw at you. Again, I gave you the handouts to hopefully give you a resource after. My information is in here as well. Feel free to call, email, whatever. The initial stuff is free. I give you guidance for free. Eventually, hopefully, you'll get your associations to consider me as the legal counsel. I'll come in and work with you, and we'll have fun. All right.
Well, you have to come back in about 6 months when everybody has been fully indoctrinated. And not anything more.
By now, your heads are all spinning. What was he talking about? It's a lot of information. Blame Sherry and Charlene and Carol, who said, we want you to include it all. So that's what I did. So there's a lot more. It's a great industry. The reason I like it is it's a mixed bag of, you deal with a lot of different people, a lot of different issues. As a lawyer, I deal with a ton of things. Fair housing, contracts, employment, real property, corporate law. So it makes it fun for me. I get some really interesting cases, so at a happy hour I can tell you all about those. But
and after the day, when you look at your documents, when you go into your association and you look at documents or you get phone calls, and you will remember some of this in a different way. It will just start to happen, and you'll have more questions. We're going to put this online on the internet for you, and if you do start to if something from the day rings a bell tomorrow, next week, email me, because we want the questions so we can go forward with other sessions that we want to hold and just have discussions about some of these things.
So,
Thank you.
Thanks, everyone. Also, our website, we have a lot of articles and stuff on our website on past issues and topics. That's also a free resource of information.